My lords, matter for end of the board, my lords. End of the board, my lords. NCLT has issued contempt. NCLT has issued contempt against me, lords, and also non-bailable warrant against me. Out of 11 lakhs, my lords, the contempt money, I've paid 5 lakhs, my lords. Despite that, my lords, non-bailable warrant has been issued against me, my lords. My lords, I'll deposit 2 lakhs, my lords, within tomorrow, my lords. Out of 11 lakhs, my lords, tomorrow, my lords. Tomorrow, 3 lakhs, my lords.
This matter pertaining to 2022. So here, the matter is pertaining to 2022, my lord.
22?
So in this, the petitioner was appointed on in the year
Next week
2019.
RFA 17 we are not taking.
Next.
13, 14 we are taking. Very few matters where we are taking 16 because suits are very old. That's how Apex Court has said, na? That's the reason. Anyway, you take it. We'll have it in the second week of February. All right. Last week of January. All right. 2014. Sorry. Week after next.
Lord, if I may mention a matter, my lord, serial number 26, I appear for the appellant, my lord. There's some inconvenience today. A short accommodation, any date may be fixed, my lord.
26, 2014 matter.
Yes, my lord. Other side, I've informed.
Week after next at the request also.
Serial number
Inform
27.
your friend also.
Yes,
Huh?
yes.
Serial number 27, my lord.
27.
Yes, my lord.
You took cue from him.
I'm for the appellant, my lord. The counsel on the record is suffering from knee pain, my lord. 2 days accommodation may be given, my lord.
Not well.
He is suffering from knee pain today.
Okay. Prakash Shetty.
No, my lord.
Appellant.
Vaskiran.
Vasakiran. Okay. Same order. Okay. At the request of.
Much better.
Yes. ಎಲ್ಲರೂ ಹಿಂದೆ ಕೂತ್ಕೊಂಡ್ಬಿಟ್ರೆ ಹೆಂಗೆ ಯು ವಾಂಟ್ ಟು ಮೇಂಟೈನ್ ಸಮ್ ಅನ್ಟಚಬಿಲಿಟಿ ಆರ್ ವಾಟ್ ಫುಲ್ ಖಾಲಿ ಎಕ್ಸೆಪ್ಟ್ ಗವರ್ಮೆಂಟ್ ಎಡುಕೇಟ್ ಶಿ ಹ್ಯಾಸ್ ನೋ ಆಪ್ಷನ್ ಅದರ್ವೈಸ್ ಶಿ ಆಲ್ಸೋ ವುಡ್ ಹ್ಯಾವ್ ಗಾನ್ ಬ್ಯಾಕ್ ಸೀಟ್ ಓನ್ಲಿ ಎಸ್
Appellant.
ಹಾರ್ನಳ್ಳಿ ಅವ್ರು ಹೊರಟೆ ಬಿಟ್ರು
The appeal is dismissed with costs. The appellants are hereby directed to hand over the possession of the social property to the respondents within a period of 3 months from the date of the judgment. They fail to hand over the possession of the social property, they are liable to pay damages of 3,000 per day.
Much. Okay.
My lord, in this matter, my lord, I will file the second set, my lord. Second set is ready. By
Ready.
oversight, RF single bench ಅಂತ ಹೇಳ್ಬಿಟ್ಟು one set ready. It is dismissed.
ಅದ್ರಲ್ಲಿ ಆಫೀಸ್
Official act. Dismissed
Counsel
for
for-
default paper book, non-filing of paper book ಆಗಿತ್ತು. Meanwhile, I will file the paper book also. That is also ready.
counsel for the appellant submits that paper book will be filed before the sunset of the day.
ಅಲ್ಲ, ಒಂದು ದಿನ ಸ್ವಾಮಿ ಜೆರಾಕ್ಸ್ ಎಲ್ಲ ಮಾಡಿಸಿ ಅದರ ಸೆಟ್
Within
ಟರ್ಮ್ ಮಾಡಿ
1 week, within 1 week, failing which appeal stands rejected on that ground. Then IS 2,
ಅದು-
192 ಏನು?
ಅದು 192 recalling dismiss for default ಆಗಿದೆ.
ಅಲ್ಲೊಂದು
Recalling ಆಗ್ಬೇಕು.
ಬರ್ಕೊಳ್ಳಿ. Two applications are filed. Semicolon. IA 1 of 2024 for condonation of delay in filing companion application in IA number 2 of 2024. Semicolon. The prayer is to recall the peremptory order dated 28/8/2013. First stop. Counsel for the appellant submits that even if the defects were rectified,
28/8 to
comma, the appeal papers would have been languishing in the cupboard of the court because appeals older than that are still languishing. First off, there is force in this submission. Next paragraph. Which book you will give to the library?
any book, my lord.
Any book?
Any ಹೇಳಿದ book.
You give your checkbook. In view of the above, the application is allowed and condonation delay is condoned. Companion application in IA number so and so is also allowed, and the peremptory order whereby the appeal was dismissed stands is recalled, subject to the condition that the appellant shall give 2 books. One, Puli Mavina Mara by P. Lankesh. And another, Papada Hoogalu, again by P. Lankesh. ಎರಡೆರಡು ಕೊಡ್ಬೇಕು. All right? ನೀವು ಓದ್ಬೇಕು. ಒಳ್ಳೆ ಪುಸ್ತಕ. ಚೆನ್ನಾಗಿದೆ ರಮೇಶ್. Both are good books. Within 2 weeks, failing which the peremptory order revives as Phoenix. Okay. ಅಲ್ಲಿ ಯಾರಿಗಂತ Advocates Association Library Science.
I'm appearing for the, I'm appearing for the appellant, my lord.
State had filed a suit for declaration and injunction, my lord. That came to be decreed, my lord. In the.
Against that
valuation-
appeal.
Yes, my lord. Valuation slip, my lord. We had contended that valuation to an extent of 3 crores 57 lakhs 125. This court had directed to ascertain on what basis this calculation was done. For that, my lord, we had filed an memo
Did
along
he,
with the
did he take
calculation.
up in his WS that the court fee,
Yes,
the
ma'am.
valuation is
No, my lord.
objectionable?
No, my lord,
No.
but there is a direction.
No, I have filed, I have filed objection. It was court has overruled, and against which I went to Supreme Court. Supreme Court remanded the matter. Thereafterwards, we have filed the objection.
Yes. What is the basis
The
of?
24/9/2024. We
ಅಲ್ಲಿ
have
ಆನ್
placed-
ಮಾಡ್ಕೋಬೇಕು.
Please,
ನಿಮ್ ವಾಯ್ಸ್ ಕ್ಲೀನ್ ಆಗಿ ಕೇಳ್ಬೇಕು.
please,
ನೋಡಿ ಆ ರೀತಿ.
24/9/2024, we have, I have placed on memo along with the documents, my lord.
24/9/90,
24, my lord.
On what basis you have valued the property?
My lord, this is, my lord, a forest land, survey number 14/1, my lord. Extent is 2 acres 20 guntas. My lord, rosewood and teak wood are there, my lord, in the said forest land. My lord, we have given document number 1 to,
How many
yes, my lord.
rosewood trees?
My lord, we
how
have
many-
calculated back and 2011, what was the valuation we have stated, my lord, at page 2 of the, at page 4, my lords. 1 crore 72 lakhs along with supporting documents.
Any objection is filed to this one?
Today I am filing objection, my lord. My colleague is submitting the copy after serving the copy of my advocate.
All right, you file in the court. Let us see. Counsel for the appellant seeks time to file objection to the memo filed by the respondent state, comma, dated 23/9/2024, accompanied by the report and documents. First, call after 2 weeks. Everyone copy, Kodi.
Obliged.
I appear for the petitioner, my lord.
Number 124, my lord.
Third ordinance is 3 times notice issued.
My lords, we had taken steps twice to serve respondent number 9, my lords, but unfortunately it was not served. So my lords, maybe we be allowed to file an application to take paper publication, my lords.
Yes. 2 weeks granted for taking steps of service by substituted mode, comma, on request, first. Failing which, the appeal runs the risk of dismissal on that ground itself. Okay.
My lords. My lords, one more submission, my lords. It's showing Shri K.S. Bharat's name, sir's name on the cause list. It could kindly be deleted, my lords. He's a judicial officer now.
All deleted under yaar new yaru.
I'm
Naveen
representing
Gudi,
Naveen Gudi.
where is the application, request for retirement? But request for retirement ಮಾಡಿದ್ರೆ we can entertain. NOC is to appear along with me, ಅದಷ್ಟೇ. NOC does not say that he be permitted to retire ಅಂತ ಹೇಳಿದ್ದೀರ ಅದರಲ್ಲಿ. Shri K.S. Bharat Kumar is permitted to retire from the case. Okay. Next.
Grateful, my lords.
Running for respondent.
TCR,
last time it was TCR was called for.
Clear ಆಗಿ ಮಾತಾಡ್ಬೇಕು ಅಂತ ಅನ್ಸಲ್ಲ.
I'm sorry, my lords. My lords, last occasion, my lords, TCR was called for. Await TCR.
When it was called for, why TCR has not come?
2 weeks.
ಯಾಕೆ ಬಂದಿಲ್ಲ? ಯಾವತ್ತು ಇಲ್ಲಿಂದ ಕಳಿಸಿದ್ರು? 8/11/24. ಯಾವತ್ತು ನಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ? 6. Await arrival of TCR.
Interim order may kindly be.
Interim order to continue.
May I request for a date, my lords?
ಹೆಂಗೆ ಸರ್ವಿಸ್ ಇದು ಬರ್ಬೇಕಲ್ಲ ಅಲ್ಲಿಂದ?
Auction.
Call
Auction.
in the second week of January. Petitioner has filed a memo. Do you oppose a
No,
withdrawal?
I'm filing the memo. The prayer of the petition has been satisfied. They've been appointed. These are the appointment orders. I'm placing it on record.
ಇಬ್ರು ಮೆಮೊ ಹಾಕಿರಾ?
ಅಲ್ಲ ನಾನು withdrawal ಹಾಕಿದ್ದೀನಿ.
An appointment order, I'm just.
ಅದು ಕೊಡಿ. Counsel for the petitioner has filed a memo seeking withdrawal of the writ petition. Full stop. Counsel for the answering respondents has also filed a memo stating that there is compliance of the order,
There was no order, my lord, but the prayer of the petitioner has been satisfied.
stating that the petition has become infructuous since prayer has been substantially granted. Right. First, that memo reads as under. Next part. In view of the above, writ petition is disposed of. Okay. Next.
Answer for the petition.
Suresha, fifth time.
ಅದು subsequent objections.
ಆಮೇಲೆ ಬೇರೆ
ಆಮೇಲೆ ಬಂದಿ 2 days time.
ಏನದು ಅಬ್ಜೆಕ್ಷನ್ ಏನು?
ಸೆಕೆಂಡ್ ಸೆಟ್ ಅಲ್ಲಿ ರಿಪೇರಿ
ಮಾಡಿಕೊಡಿ ಮಾಡಿಸ್ರಿ ಎಲ್ಲ ಮಾಡಿಕೊಡಿ, ಕೊಡಿ ಅವ್ರಿಗೆ ಕೂತ್ಕೊಳ್ಳಿ, ಎಲ್ಲ ಸರಿ ಮಾಡಿಕೊಡಿ, ಕೊಡ್ರಿ ಎಲ್ಲ ರೆಡಿ ಮಾಡೋದು ಸರಿ, ಆಮೇಲೆ ಕಳಿಸಿ ಪಾಸ್ ಓವರ್. ನಿಖಿಲೇಶ್ ರಾವ್.
I appear for the respondent, my lords. I seek a week's time for objections.
You want to file objections?
I'll file my objection, my lord, a week's
Office
time.
objection, submission, another office objection
I appeal for the petitioner, my lords.
or 6R? And directly made party and they were not be parties before the tribunal. ಸಾಮಾನ್ಯವಾಗಿ ಟ್ರೈಬ್ಯುನಲ್ ಮುಂದೆ ಪಾರ್ಟಿ ಇರ್ಲಿದ್ರೆ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡು ಇಂಪ್ಲೀಡ್ ಮಾಡ್ಕೋಬೇಕು.
Agree, my lords. My lords, he was a
ಒಂದು
part.
ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಕೊಡ್ಬೇಕು ವೈ ಯು ಆರ್ counsel submission is accepted and therefore office objection is over. You want time?
Please, my
2
lord.
weeks for filing of statement of objections, if any, failing which the right to file one stands forfeited. Yes.
Grateful, my lords.
Lots is, this matter 2:30 minutes. I'll argue this matter at 2:30.
Ask.
Please.
But in this case,
Ah.
originals have to be secured. I will secure the originals. We had some other day.
Ravi, next week ಹಾಕೋಬೋದಾ?
Lords,
ಏನ್ urgency ಇದೆಯಾ?
there is an urgency, my lords. The grievance is, lords, this is the second round of test which was conducted for the sub-inspector's exams. First round of test was conducted by the department itself. They conducted 2 evaluations. Now, this honorable court felt, my lords, there was an allegation pertaining to the
ನಾಳೆ
recruitment
ಹಾಕ್ಬಿಟ್ಟು.
process. Tomorrow,
ಅಲ್ಲಿ ನಾನು ಊರ್ನಲ್ಲಿ ಸರ್ ಸ್ಥಿತಿ ಸರ್.
ನಾಡ್ದಿರ್ತೀರಾ?
day after tomorrow. Please, my
Day
lord.
after.
Day after tomorrow.
Call a day after.
Friday minutes. Day after tomorrow, there's some,
ಬೇರೆ ಮ್ಯಾಟ್ರ್ ಇದೆ.
please minutes. Friday.
ಏನ್ ಭಾಳ ತಗಲ್ಲ ಅದು ಮಧ್ಯಾಹ್ನ ಇರ್ಬೇಕಲ್ಲ.
No minutes, my lords have fixed that sub-register full day it is fixed before case set.
All right.
Monday, my lords.
Let it be on Friday, my lords, because. if-
Friday bench ಇಲ್ಲ.
Bench.
Friday,
Monday.
ರಜೆ ಮಾರ್ನಿಂಗ್ ಇರುತ್ತೆ ನಮ್ದು bench. All right, Friday.
Friday, please,
Friday.
please.
ಬೆಳಗ್ಗೆ ಮಧ್ಯಾಹ್ನ ಸಿಂಗಲ್ ಇರುತ್ತೆ. Friday.
Friday, my lords, it may not take much time.
ಅಲ್ಲ ಫ್ರೈಡೆ ಬೆಂಚ್ ಇಲ್ಲ. ಐ ಆಮ್ ಎ ಪಾರ್ಟ್ ಟೈಮರ್. He is also.
Can I request then tomorrow itself, my lords? I
ಇಲ್ಲ,
take
ಇವರೇನೋ
it
ಊರಲ್ಲಿ
as-
ಇರಲ್ಲ ಅಂತಾರಲ್ಲ ರಮೇಶ್.
sorry, my lords.
Monday.
I'm sorry. Please.
ಅಲ್ಲೇ ಯಾರು ರಾಘವೇಂದ್ರ ಗಾಯತ್ರಿ ರಿಟೈರ್ಡ್ ಸನ್. ಓಕೆ. ಆಲ್ ರೈಟ್, ನೆಕ್ಸ್ಟ್. Sampreet,
Filing a memo for withdrawal, my lords.
Travel,
Withdrawing the petition.
not happy with the court or what?
Oh, my lord.
ಬರ್ಕೊಳ್ಳಿ. Petitioner has filed a memo seeking leave to withdraw the petition. Full stop. Learned AGA on request appearing for the respondent signifies consent for withdrawal. Full stop. Memo reads as under. Next, in view of the above, petition is disposed of as having been withdrawn. Okay. ಅಲ್ಲಿ ಮೊದಲು ಎರಡು petitioner has filed a memo seeking leave ಇದೆಲ್ಲ ಅಲ್ಲಿ ಬರ್ಬೇಕಿದೆ. Memo reads as under. ಅದಾದ್ಮೇಲೆ next. Yes. Sahana Devanathan. Yes. Form A and B has not given. You have to obtain Form A and B, na?
Well, my lordships, I have been appearing in MFA. I already appeared before the committee.
Ah.
And I have already been appearing before and arguing the matter
No,
before that one.
but still our rules require, it's MFA, it is WP. So formally you can mention that also. They will favorably consider, but that's the rule. Once we relax, others will start.
But this matter is a little bit urgent.
Urgent.
So, yeah,
Urgent for him or you?
urgent for me, my.
How, any entry order is there?
For me, yes, my lord, there is an
Entry order.
Yes.
You go before the committee, we'll fix one date. Barkali.
My lordship, I may be permitted to appear before the court because I have already been appearing before the High Court and other courts, and I may kindly be permitted.
No, that cannot be done because it becomes a precedent for rest of the people. Though we know that you will be able to argue, but there is a procedure. You go, it will fix it tomorrow. Are you going there tomorrow?
Yeah, tomorrow it will be.
Barkali. Respondent party in person to appear before the committee, before the something, so committee seeking leave to appear in the matter. First up, committee to expeditiously take the decision. Petition. First, registry to share a copy of this order with the party in person. First, call this matter immediately after a memo is moved by the respondent on obtaining the permission. Okay?
The interim order
Share
may
that
be,
copy. Interim order to continue till
Great.
next date of hearing.
My lordship, the matter is pending before the, this consumer court, and this has been
You
stopped.
can speak only after permission is granted. Yes.
grateful.
Anil Kumar? Any,
I appear for the petitioner in this matter, my lords.
translation
This-
dismissed.
Selection matter, my lords. Petitioner's candidature to the post of forest watcher is rejected on a hyper-technical ground that the document.
It argued before us.
No, my lords, I had mentioned the matter.
Okay.
I had mentioned the matter. So I produced the Kannada version along with my application. During document verification, I give English version.
That's
My
the reason on
candidature
which
is
it-
rejected. My status of me being a scheduled caste or that is
not
not disputed.
Our constitution is in English.
Yes.
What do you say? No argument. But Jesus did not know English. The best biographers of Jesus, they say, like Emil Ludwig, etc., that Jesus did not know English at all.
They had uploaded Kannada documents subsequently. at the-
Constitution is in English. Baba Sahib gave constitution in English language. How can you say? English is a language. In fact, MC Chagala, Justice MC Chagala, after he became education minister,
Please.
he wrote a book, Shikshana Mattu Bhashe. In Kannada, I read it. Somebody had translated. I do not know. Maybe that Raghavendra Rao translated it. He says, English gave unification not only to the political idea of nation, but also to the freedom movement. He writes that way. Maybe all our language of high courts in the country and language of the Supreme Court, Constitution says, shall be English. ಆಮೇಲೆ ಕನ್ನಡ ಹಾಕಿದಾಗನೇ ಇಂಗ್ಲಿಷ್ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಕೇಳ್ತೇವೆ ನಾವು. ಅವ ಪಾಪ ಇಂಗ್ಲಿಷೇ ಕೊಟ್ಟಿದ್ದಾನೆ, ಅವನೇ ಇಲ್ಲ ತೋಣಲ್ಲ ನಿನ್ನ. ಇಫ್ ಇಟ್ ಇಸ್ ಫಾಲ್ಸ್, ಐ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಅಂಡ್ ಹಿ ಇಸ್ ಎ ಮೆಂಬರ್ ಆಫ್ ಶೆಡ್ಯೂಲ್ಡ್ ಕಾಸ್ಟ್. What kind of government?
Was
I do
clearly
not- we do
mentioned
not
in the-
understand. At least ಹಾಕಪ್ಪ ಕನ್ನಡ ಕನ್ನಡವನ್ನ ಪ್ರೀತಿಸೋದು ಬೇರೆ,
Please.
ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಕಾಪಿ ಹಾಕೋದು ಬೇರೆ. You may be a very good translator. You may not have any love for Kannada at all. What is this? On what ground you are denying candidature?
Lords, I
On the
must
ground
also-
that he has put it in English. ನಿಮ್ಗೂ ಸ್ವಲ್ಪ ಕನ್ನಡ ಹಾಕಿದ್ರೆ ಇವೆಲ್ಲ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಿರ್ಲಿಲ್ವಾ?
My lords, that's an online application. The
So it
applicant
has to
did
be
not-
in English.
No. The applicant could not retain a copy for herself as to what document she had produced. Kannada version ide, English version ide. So for
But
second
how tribunal saw this matter?
tribunal.
Did you tell the tribunal that language of our constitution is English? That did not perhaps. Perhaps you
that
also did
contention
not.
I
You
did
did
not
not appear there.
Para 14.
I did, my lords.
Page
Paragraph
29.
13, 14 and 15, my lords, page 29 and 30 of the impugned order.
13, 14, 15.
Yes, my lords.
ಮೂಲ ದಾಖಲಾತಿಗಳ ಪರಿಶೀಲನೆ.
They have extracted, after noting the contentions, they have extracted the notification. Are exact documents ಕೊಡ್ಬೇಕು ಅಂತ ಇದೆ ಅನ್ನೋದನ್ನ note ಮಾಡಿ. They say that it cannot be relaxed. My contention.
Certificate was issued in which language?
Because there are two certificates which are issued, one in 2017 and one in 2022. The first certificate in 17 is of Kannada, is in Kannada language, 22 is in English language.
Which they had issued.
Tahsildar, the competent authority, has issued the certificates on both the occasions.
English, one is in English and another is.
Yes, my lords.
What is the format in your, it is under 2000 rules, under 1990 Act? The scheduled caste, scheduled tribe, reservation in appointments, etc. Very 1 mile long title is there, na?
Yes.
That act.
With regard to the caste certificate, my lords. Yes, my lords. The caste certificate, I've produced it as.
Where is the format?
My lords, format I have not produced.
Which rule?
My lords, this is Namune D,
No,
Form D.
Page
can't you
74.
understand? There is 1990 Act.
Certainly.
Under that, rules have been promulgated. They have been amended in 2004. There they have provided the format. Bring that format, bring those rules first. That
Certainly.
was post Madhuri Patil versus State of Maharashtra.
Certainly, my lords, I'll produce that and I'll
Promulgated the
also
rules.
look at that, my lords. I have
Bring-
not,
Bring that, bring that. Now, pass over.
yes, my lords.
Okay.
Much obliged.
In one judgment we have held, Justice Bhaskar Rao and Honorable Chief Justice Bhaskar Rao and another judge, they held the formats are not rigid formats. And they have mentioned one line about language also, even if it is in English. At the most, you can call him
Yes.
Kannada Kodappa ante ಹೇಳಿ, Kannada Kodappa.
I
See,
have
one
produced it.
candidate.
I have produced my Kannada version afterwards while
Afterwards
giving
also
my
it is given.
objections.
But
Objections.
just go to library, spend a few minutes there,
Yes, my lords, I'll get the rules.
pass over.
That appear for the appellant and sought for extension of the time to complete the mediation process. My lord, yesterday I have
Suit is of which year?
suit
2017, Manu.
2017 suit.
So.
2008. Suit for partition filed in
Which
the
year?
2008.
2008.
2024, July, this honorable court sent it for mediation. And there are about 28 respondents, my lord, dependent. Suit is partly decreed under Aliasantana law. And in respect of the certain schedules, the appellant is challenged the decree. And I am told yesterday.
You were a
that
defendant.
I am the plaintiff.
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 So in respect of certain properties, share is not given.
A share is not given, major portion of it. And yesterday I'm told, I called the parties, they say maybe at the most 15 days, it should be over. 2 persons have to sign it out of 28 persons. Report is ready.
Ready.
Report is ready.
Call this when?
My lord, 20 days.
Call after 3 weeks as requested at the bar for possibly, hopefully reporting settlement.
Settlement. Please.
In application in IA number 3 of 2024 supported by a narrow narrative affidavit. Objections hakila yaru. And
They also want. They
extension.
also want.
It's settling, my lord, as per my client instruction. also.
Is allowed because of consensus at the bar. And extension as sought for is granted.
Please.
Okay.
Please.
ಇನ್ನೊಂದೇ ಇಂಪ್ಲೀಡಿಂಗ್ ಏನದು?
ಅಲ್ಲ ಇಂಪ್ಲೀಡಿಂಗ್ ಈಗ ಬೇಕಾಗಿಲ್ಲ ಮತ್ತೆ ನೋಡ್ಬೋದು ಅಂತ ಕಾಣ್ತದೆ.
The application seeking impleadment is disposed of as not being pressed. Okay. Next. ಏನಿದೆ? ಬರ್ಕೊಳ್ಳಿ. 2 applications. Order dated, recalling the order dated. 2 applications are moved. One is IA 1 of 2023 for recalling the peremptory order dated 17/11/2022. And the other is IA number 2 of 2023, which seeks condonation of short delay of 59 days in filing the recalling application. First, both applications are supported by affidavits. First off, matter appears to be meritorious, prima facie. First off, if recall is not granted, if request for recall is not granted, appellants are likely to be. That's 23 application. Anyway, in the above in the above circumstances, the application in IA number so and so is allowed and delay is condoned. there being plausible explanation, therefore, full stop. Application in IA number so and so is allowed, and recalling the peremptory order is recalled, subject to the following two conditions. Number one, the appellant shall comply with the office objections within 2 weeks. Ernesto, the appellant shall present a set of 3 books to the association library. Books being ವಕೀಲರ ವಗೈರೆಗಳು by C.H. ಹನುಮಂತರಾಯ. ಚೆನ್ನಾಗಿದೆ ಆ ಪುಸ್ತಕ, ತಮ್ಮ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಎಲ್ಲ ಬರೆದಾರೆ. ಅದನ್ನ ಯಾರಾದ್ರೂ ಇಂಗ್ಲಿಷ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಇಟ್ಸ್ ವೆರಿ, ಕನ್ನಡದಲ್ಲಿ ಅಷ್ಟೇ ಇರೋದಕ್ಕೆ ಬರೀ ಕನ್ನಡಿಗರು ಓದ್ಬೇಕಾಗುತ್ತೆ. ಬಟ್ ಇಟ್ ಹ್ಯಾಸ್ ಮೆನಿ ಆಸ್ಪೆಕ್ಟ್ಸ್. ಹೌದು, ಕನ್ನಡ ಪ್ರೀಮಿ ಅಂದ್ರೆ ಇಂಗ್ಲಿಷ್ ದ್ವೇಷ ಮಾಡೋ ಆಗತ್ತಿಲ್ಲ. ಹೆಚ್ಚು ಜನರಿಗೆ ಇನ್ನೂ ಗೊತ್ತಾಗಬೇಕು ಅಲ್ವಾ? ಅಲ್ಲಿ ವಿದಿನ್ 2 weeks. ಕೆಳಗಡೆ failing which the order now recalled would revive as Phoenix. Okay. ಅವ್ರಿಗೆ ಯಾರಿಗ ಒಂದು ಫೋನ್ ಮಾಡಿ ಹೇಳಿ, ಅವ್ರಿಗೆ ಫೋನ್ ಮಾಡಿಕೊಂಡು. ಎಸ್ ಏನು ರವಿಶಂಕರ್, what is dispensation? Dispensation granted.
Notes the transfer of medical officers is regulated under the Act of 2011 and the rules framed thereunder.
Separate act is there.
There is a separate act,
Okay.
which is called as the Karnataka Civil Services Regulation of Transfer of Medical Officers and Other Staff Act of 2011, and there's a rules framed thereunder.
Sometime anybody argued this matter before us?
No, my lords.
Not like.
In the context of,
Therefore I felt. Okay.
Now, the only grievance is this, my lords. There is a requirement of publication of all the vacancies which will fall either vacant or which is required to be filled up by means of counseling. Rule 5 is the procedure where it says that all vacancies will have to be notified as a provisional list.
So that counseling becomes meaningful.
Yes, it becomes meaningful. Our short grievance is threefold. This list does not contain 3 types of vacancies. Number 1, Bangalore urban vacancies is kept, my lords, out of the purview of this counseling process. There are 36 vacancies. When they published the list, we raised our objections. They initially said 36 vacancies are available. But when the counseling process started, they said only 9 we are leaving for counseling. So remaining they withheld. That's not what is now available for counseling. So it is not available for the choice. Number 1. Secondly, my lords, in respect of 3 categories, which is the anesthetist, gynecology, and pediatrician, the Rule 5 notification said there are 172, 140, and 123 posts respectively. But when the counseling started, they reduced it to 55, 22, and 40 respectively. That means Rule 5 notification is given up.
The element of choice enacted in the rules promulgated is lost.
Is lost. Lords, this is the second category. Lord, then the third category is, Lords, there are about 177 sanctioned posts of the Health and Family Welfare Department in medical colleges. These 177 posts were notified. But in the counseling, it is again not available. So essentially, my lords, about 250 posts, and more prominently, my lords, what is not available is the Bangalore urban posts. My lords, we have produced documents to show that this Bangalore urban is more in the nature of the postings given by virtue of the letters and not by counseling. Chief Minister recommends a person is retained in Bangalore for almost 14 years who happens to be the wife of a IAS officer, for 20 years who happens to the wife is an IAS officer. Another minister is given a letter and the person is transferred from Bangalore to Ramnagar, Ramnagar to Bangalore. So this is what is happening so far as the Bangalore is concerned.
No heart specialist. Heart specialist is
even there, what is the problem is the counseling process when it starts.
No, we asked that because no heart specialist would have come here, because some people say Bangalore has no heart at all. Therefore, I asked. How are you doing this?
I'll just pass on this.
How is the scheme of the act?
The
Let us,
scheme of the act.
whether
But-
it gives elements of choice?
My lords, there is an element of choice. My lords, in fact, when they first approached, the two matters, my lords, arise out of the final order, my lords, passed by the Karnataka State Administrative Tribunal. My lords, these are all mismatched doctors, specialists. My lords, the concept of mismatch is this. It arises only in respect of a specialist. For example, a pediatrician is, my lords, occupying a post, my lords, of a general physician. Or OBG person, my lords, is occupying a post of an anesthetist. So this is what is called as a mismatch. Under the scheme of the act, my lords, first we have to do the mismatch counseling, where we have to cure this
No,
mismatch.
they should know
Please, my lords.
how many posts, how many
Please.
vacancies.
We did, my lord. In fact, we have crossed that stage. My lords, they approached the tribunal, their grievance was that mismatch counseling is being done first. Thereafter, you're doing a public interest counseling. The entire counseling has to be done in one phase. And my lords, their grievance also was a short time was being given for the purpose of filing objections to the list, vacancy list. My lords, tribunal, we made a submission before the tribunal. We are extending the time limit for the purpose of filing objection. We will finalize the vacancy list and the priority list. Priority list is the seniority list.
Let us see the statutory scheme.
Please, my lords.
Give the statute.
We just pass it on.
Is a complaint
Please, my lords.
that
I will come to
the wife of
Please, my lords.
IAS officer is
No.
here
Please,
for 14 years.
please.
Another wife of another officer is shuttling between Bangalore and Ramnagar. Is it true?
No, my lords, I'll just come. My lords, insofar as those complaints are concerned, my lords, mismatch counseling was completed. Thereafter, my lords, they approached this on.
1 second. We'll see the statutory scheme now.
Lords, page
Which
number
section?
1, statement of objects and reasons, your lordships may kindly take notes.
Act to provide for regulation of transfer of medical officers and other staff of the Department of Health and Family Welfare so as to ensure the availability of medical officers and other staff in government hospitals in rural areas. Object is that rural areas get the doctors.
Yes, rural
It's
areas.
like
gets the
2012
doctors.
Act.
Yes, then thereby achieving the following objectives, namely transparency in transfer through process of counseling. This is the first object. Ensuring minimum years of service in rural area in respect of medical officers and other staff. Ensuring that specialists or senior specialists work in a post commensurate with their qualification, hence the bill.
ಮೂರಿದೆ.
3 objects.
ಒಂದು first
One
is
is transparency through counseling. Rural.
rural is first because ಯಾರು ಹಳ್ಳಿಯಲ್ಲಿ ಹೋಗಂಗಿಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗ್ ಹಳ್ಳಿಯಲ್ಲಿರೋ ಜನ ಅಲ್ವಾ?
Now the petitioners who have now come before your lordships have served more than double and triple the period of what is provided as the minimum service in rural areas.
Anyway, such statutes are made to give effect to public opinion.
Yes.
Public opinion is that all want to concentrate in cities and towns, urban areas.
Now,
Nobody wants to come to villages.
that's what happens. There are fixed number of posts in Bangalore urban area. So there is no way that everybody can be accommodated. But this is where the problem lies. People who are already accommodated do not want to go out.
Go out.
We are people who are working in rural areas for even 20 years. We don't get a chance to get inside. We don't get even an urban area, my lords, in the district headquarters.
Which provision mentions about section 3?
Mutual
What is meant by counseling actually? Any definition?
May I just kindly have a look at page 2 also, my lords. There is
2I.
no, before that, may I just take this page 2, my lords. Page 2 in this, there are more number of officers and staff who have completed 10 years of service in the same place.
Page 2.
Page 2, my lords, in the very same, because Act number 2011, Act 2 is amended in Act 34 of 2017. I am reading the objects of Act 34 of 2017.
2017.
Yes. There are more number of officers and staff.
Yeah, other compulsory service act is different act.
Yes.
It's a different legislation,
yes.
but they have got kingship,
That's true.
a kind of.
Then, in order to transfer them in public interest, it is considered necessary to increase the 5% of transfer of medical officers and other staff to 15% by amending section 6 of the Karnataka State Civil Services Regulation of Transfer Act of 2011. Lords, I take your lordships because what the legislators found is that there are some people who are working like 10 years, 15 years, 20 years, more than 10 years essentially, and they were never getting into the chance of counseling at all because they had pegged the counseling process for certain posts at 5%. So they increased it to 15% under Act number 34 of 2017. Now your lords may kindly take page number 4, process of counseling.
Public interest is necessary to increase the 5% of transfer. What is meant by that 5%, 15%?
Earlier, my lords, what happens? The total number of vacancies which is available, yes,
Given
total number of cadre strength is taken at 5% for the purpose of enabling the transfer in public interest, which is increased to 15%. The counseling takes place. But there was an exception where 5% of the total cadre strength could have been subjected to transfer otherwise than by counseling in public interest, which is now increased to 15%.
15% by 2017 amendment.
17 amendment. Lords, may kindly have a look at page 4, my lords. That is section 2I.
Counseling process.
Process of counseling means the process of giving opportunity to a person considered for appointment or transfer to opt a place or post on priority, which is being given based on the length of service put in by him
In the place or zone where he is
zone
working.
where he is working, and such other criteria as may be prescribed. So now, if I am there is a criteria, my lords, as to how a seniority list is prepared in the provisional list. So person who has spent more number of years in a given place, he will be placed at the top. Then the person who has spent lesser number of years, again, he'll be placed at the bottom. Then other criteria may also be applicable if the rule provides for it. I'll take your lordships to the rules. But principally, my lords, the criteria is that the person who has served more number of years, he should get a priority of opting. That's the whole object.
Okay.
Then your lordships may kindly take, my lords, page number 6, section 6.
In other words, the scope of choice is directly proportional to length of service he has put in designated area.
Yes.
Okay.
Now section 6. Yeah, at page 6 minutes. The medical officer or other staff who is in the service or
read 3.
I'm sorry, minutes. I'll read 3 and then go to section 6. The transfer or promotion of a medical officer or other staff under this act shall be done through a process of counseling conducted in such manner as may be prescribed, provided that provisions relating to transfer through process of counseling shall not apply to the posts identified as project posts, posts of district health and family welfare officer, district surgeon, principal or institute, joint director, deputy director, superintendent of major hospital, so and so, and director Ayush, so and so. These are all
Except these all other will come within the
purview of the counseling. These are all administrative posts.
Correct.
Lord, there is a circular of 26/2011, if I remember. Lordships have considered, my lords, yes. So that is so far as the administrative posts are concerned.
Okay.
Then compulsory appointment of a medical officer or other staff in rural areas. Then I will come to section 6, my lords.
5 also just.
I'll read it, my lords. I'll read it.
No
read it
specialist or senior.
This is a mismatch category, my lords.
Mismatch category.
Mismatch.
Correct.
That is important.
No specialist or senior specialist with
Five is
postgraduate
important.
degree or diploma
That is important.
shall be posted or transferred to work in a post which is not identified as a specialist post related to commensurate to the subject or specialization in which he possesses postgraduate degree or post-graduation diploma. Where a specialist or a senior specialist who is working in a post which is not identified for the postgraduate degree or postgraduate diploma specialization which he possesses on the date of commencement of this act, he shall be transferred to the post identified as the specialized qualification possessed by him, provided that the provisions of this section shall not apply to the post of district health officer, so and so, so and so. All administrative posts again stands excluded.
Public interest.
Then
Transfer in public interest.
medical officer or other staff who is in service on the date of commencement of this act has completed the prescribed number of years of continuous service in any government hospital or government institution in any area or zone may be transferred through process of counseling by giving priority to persons put in longer period of service in that area or post and considering such other criteria as may be prescribed to another government hospital or government institution in the same area or zone or to any other zone or area in the following order, namely rural area,
Zone B
in
is
urban
urban area, zone A in urban area. Provided that the total number of such transfers during the year shall not exceed 15% of the number of the working strength. The medical officer or other staff on reinstatement from suspension shall not read this.
May not.
Then your lordships may kindly come to the rules.
This act overrides other states.
Yes. At page 10, my lords, is the rules.
Okay.
Lords, competent authority is important, my lords. Because competent authority is also defined under the act itself under section 2C.
3 also defines now.
Yes, my lords. Section
three.
3, my lords, and section 2C means the authority competent to make orders of transfer. Section 2C
means the authority competent to make orders of transfer of
a medical officer or other staff. Now, competent authority, my lords, is rule 3.
They have enlisted under 3.
Yes.
Category of posts, so who will be the competent
Will
authority?
be competent authority. Senior specialist, deputy chief medical officer, senior medical officer, general so and so.
Commissioner.
Is commissioner.
Director of Health and Family Welfare in respect of group B, C, D.
Yes.
Director Ayush, Director of. Ayush is allopathy, yoga, Unani, Siddha, homeopathy.
Yes.
Correct?
Yes.
Yes.
Then rule 5.
Rule 5.
The state government may from time to time specify by order the details of various posts identified in various government hospitals for the specialists and super and senior specialists possessing a particular postgraduate degree or postgraduate diploma qualification. This is number 1.
Specification.
Yes. Lord, this is the specialist posts. This is the specialist posts.
Correct.
Next. The competent authority shall prepare and publish list of specialists and senior specialists who, as on the date of commencement of the act, are working in posts which are not identified by the state government for the particular specialized qualification possessed by them, and take action to transfer them through counseling to the respective posts which have been identified for the particular specialized qualification possessed by them. Lords, that is mismatch, lords, as on the date of commencement of the act.
Section 5.
Section 5. They will have to be accommodated in the specialized posts meant for their qualification. Procedure in transfer of specialists or senior specialists to the respective identified post shall be as follows. Publish the list of provisional list of specialists and senior specialists in the order of their seniority who, as on the date of commencement of the act, are holding posts which are not identified for the specialized qualification possessed by them in the notice board of the department and the department website 7 days to file the objections. Notify the specialty-wise vacancies available in various government hospitals. Publish the final list of specialists and senior specialists who are transferred under sub-rule 2. Counseling of the specialists and senior specialists. Issue transfer orders. This is the process.
Publish the final list of specialists or senior specialists who are
to be transferred as per sub-rule 2.
It's a provisional list.
Yes. Lords,
Final
A is
list
provisional list.
Why do they call it as final list?
Lords, A is the provisional list. B
No,
provides.
If
yes.
You pass the final list in 3C,
Lords, then
where is
counseling.
the question of going for counseling?
Lords, what happens? Publish the final list of specialists and senior specialists who are to be transferred, not to a given post.
Okay. These are persons who are to be transferred. Now
Yes.
come for
Lords,
counseling.
They are the people who will be eligible to participate in the counseling.
Correct.
Then counseling. Then issue of the transfer orders.
This is the scheme.
Yes.
Transfer of medical officers and other staff. Your case fits into which rule?
Milords, then your lords may also see 6 milords. Milords, our case falls under 3A being violated when the final list is published under 3C and they have not adhered to the number of years of service, as also the competent authority has not issued the transfer orders. These are the contentions raised. Then kindly have a look at rule 6.
Transfer of medical officers and other staff. A medical officer and other staff who has completed the minimum number of years of continuous service in a government hospital or government institution, as specified in the table below, may be transferred to another government hospital or government institution in the same area or zone, or to any other area. Government servants holding Group A posts is 3 years. They are all Group A post minutes. Then next, minutes, I'll go to the zones also. Minutes. Zones is important, but procedure in transfers through computerized counseling. That is what they are presently following.
Computerized counseling andre?
Computerized counseling, minutes, is that the option entry can be made by logging in. It is not necessary for a physical counseling where we are given the list of, not similar to what happens in the KEA, minutes. The counseling happens in KEA. The similar system is adopted. It is not necessary for it. It's an option filling. Then this is something which they were required to follow, minutes. Kindly have a look at Rule 7. The transfers in each category of post through computerized counseling shall be in the following order. Transfer under subsections 2 and 3 of section 4 and subsection 2 of section 5. Transfers in public interest under subsection 1 of section 6. Other transfers under subsection 1 of section 6. Then procedure in transfer in public interest under subsection 1 of section 6 shall be as follows. Publication of list of medical officers and other staff based on their total length of service who are proposed to be transferred in public interest. Notification of vacancies proposed to be filled up. Counseling of candidates. Procedure for other transfers shall be as follows. Notification of vacancies, last date for submission, scrutiny of applications, publication of provisional list, submission of objections, publication of priority list, and then the counseling.
Yes.
Then zones, milords, is what your
notification of vacancies in.
Yes. Then notification of vacancies, list of vacancies that are
Shall be
filled up, shall be displayed in the website of the department. Consequential vacancies that arise at the time of counseling shall also be included in the list of vacancies and displayed on the computer screen when the vacancies arise.
Admission ಅಲ್ಲಿ ಮಾಡ್ತಾರಲ್ಲ,
Admission ಅಲ್ಲಿ ಮಾಡ್ತಾರಲ್ಲ, same. ಯಾವುದು ತಗೊಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ automatically it gets into the seat matrix ಅದರಲ್ಲಿ. This is the vacancy matrix.
All other transfer applications shall be.
All other transfer applications shall be submitted to the concerned heads, etc. Milords, I will not read this and then come to 10, Rule 10.
Preparation of priority list.
Yes. All the verified applications shall be arranged in the following order of priority, namely the terminally ill cases, persons who are due to retire on superannuation, physically disabled, cases of widows.
ಡಾಕ್ಟರ್ಗಳಿಗೆ ಹಿಂಗಿತ್ತು ಅಂದ್ರೆ. Not patients.
Not patients.
Because the virus and bacteria do not spare doctors. Yes.
Lords, I will skip the explanation then. Within each of the above categories, priority list shall be prepared by multiplying the number of years of service of the applicant in all cadres in places classified as Zone A, Zone B, and rural area. The weighted ratio allotted to the respective zones as specified below to get the weighted service in years. This is the formula. Zone A, completed number of service in all cadres in Zone A into 100, into 1. Zone B, completed years into 1.5. Rural areas, completed area period into 2. This is the weightage. The staff with more weighted service shall be considered above the staff with lesser weighted service while preparing the priority list. In case of ties, seniority of the individual shall be taken into consideration.
ಎಲ್ಲ ಸಮ ಇತ್ತು ಅಂದ್ರೆ who is senior in service?
In service.
ಅದ್ರ ಮೇಲೆ ಮಾಡು.
Yes. Then the competent authority shall prepare the provisional priority list as explained above, and the same shall be notified in the notice board and on the department website, inviting objections within a period of 7 days, if any, from the persons likely to be affected. Thereby, immediately after the due date of receipt of objections, all objections received shall be considered and the priority list shall be finalized. Then general instructions regarding counseling is there. Then Rule 13, milords. Rule 13, 14, and 16. The candidates on the priority list shall be intimated about the dates for counseling through departmental website and the press notes. On the date of counseling, the candidate shall be called in the order of priority and shall then be asked to choose any one of the vacant posts available at such session and displayed in the computer screen. If a candidate fails to turn up for counseling as per his turn at appropriate point of time, his claim shall be passed over and the next candidate in turn shall be called for the counseling.
So passed over is there, even there also?
There also a passed over is there.
Okay, it's just not the prerogative of the lawyers.
Just to be on the lighter side, Minots.
Yes.
I remember that when Justice D.H. Vegela was the Honorable Chief Justice, a new entrant to the bar came and said, Lordship may kindly pass away.
Pass away. Perhaps
Passed away.
that's the innate prayer of everybody who will ask me.
So, like, there was like some kind of uneasiness which I could find in the court. Some people were actually at laughter. Some people were frightened how the bench is going to respond because this junior advocate has said like this. But the Honorable Chief Justice, through his wits, said, if lawyers like you keep frequenting to the courts and make such requests, that day is not very far.
There is one concept like Freudian lisp. Freud, Sigmund Freud, he say, what lurks inside the mind gets expression by slipping on the tongue.
Yes.
That's called Freudian lisp or slip. Slip, both there. Lisp appears to be todalu. If I want something to happen,
yes,
whether I intend to put it out or not, the words will dole out on the floor of the mouth.
Yes.
Anyway, that lawyer did not say, pass away immediately.
Yes.
And he said, he only said, remind
So
it.
that discretion was still at the hands of the bench, Minots.
Yes.
That's then Rule 13.
But one thing,
Yes.
Shankar, the humor is lacking in the bar bench. Humor, wit, so much important. In
Minots,
many-
the whole difficulty, Minots, what I found is this. I also got used to it. Now I'm again reverting back. Because I
No,
also...
nowadays you are smiling.
It's not, of course. Minots,
Whether pocket has anything to do with that.
absolutely nothing to do with it, Minots. Now, now the only thing is this, Minots. Earlier, we were confined to the libraries and the books. So the manner in which we used to have an exposure or to the information was completely distinct. It was not focused on what I wanted. It was holistically the whole subject where I used to search what I wanted. But now once I got used to this, the search engines, Minots, in various, so it was like completely focused. I want something now, AI is come. Immediately I know what is the argument which I am required to canvass. That is the kind. Notes, this is something which deprives us of a holistic knowledge of the subject. So now I have reverted back. So now I have again started taking the books. Of course, I use this computers also, but now again I have started reading the books because there is a larger perspective with which I can understand the subject. And one thing I should never discount is the way in which the writer presents the subject makes a lot of sense in understanding the law. That's where the entire thing makes the difference. How he presents.
Humor, which Homer said, Homer, the author of Iliad and Odyssey, Greek writer. A civilization's standard is measured by the quantum of humor.
Humor, yes.
That springs in the interaction of the commoners. Therefore, our DVG, there are some muktakas in Mankutimana Kagga. Nagu Sahajada Dharma, something like that. Nagi Sivizu Paradharma, Atishayada Dharma, something, then it goes Naguta, Nagisutta Nibalo, something like that. Be always smiling. A smile is a beautiful ornament. Yes.
Then Rule 13.
Professions are changing its
The dynamics is completely changing.
because of technological
advancements, yes.
And especially for legal profession, there is an observation. There is a book by Richard Susskind, The Future of Profession.
Profession, correct.
What will happen to the future of the profession if the technology
is taking over to such an extent?
But no technology said, don't smile.
Yes.
Any
No, that
computer,
is-
any internet said that?
No, certainly not. I think the internet says it, otherwise that we should always keep smiling.
Yes.
That's Rule 13. The candidates on the priority list shall be intimated about the dates for counseling through departmental website and the press notes. On the date of counseling, the candidate shall be called in the order of priority and shall then be asked to choose any one of the vacant posts available at such sessions as displayed on the computer screen. If a candidate fails to turn up for
You read
counseling,
it, na? Pass over, etc.
Yes.
Okay.
then next, issue of orders. The competent authority shall issue a transfer order as per the choice of the candidates on the spot, duly deleting the vacancy from the list of vacancies and also incorporating the new vacancy caused due to such a transfer order. The competent authority shall also
He has
issue
no
transfer
choice.
orders. Yes.
He has no choice.
He has no choice. This is computerized counseling. Notice option is there. I am in the top of the priority. I choose it. Then competent authority shall issue the transfer orders, and it's only for the competent authority to issue the transfer orders. Nobody else comes within the realm, my lords, of this process.
Only perhaps they wanted to keep all those people away
Yes.
from this process.
Yes.
Ah,
The
this is
competent authority shall also issue transfer orders, so and so. That is, the competent authority shall also issue transfer orders in respect of such candidates who fail to appear for counseling or fail to make selection during the council, or as per suo motu allotment made at the time of counseling. Copies of such orders must also be sent to the concerned authorities. Then process of transfer shall be continued till the specified upper limit of number of transfers is reached or till priority list is exhausted, whichever is earlier, within the time frame communicated by the competent authority. Then the list of transfers effected, indicating the places of transfers against the names of the officers and officials so transferred, shall be displayed on the notice board of the competent authority as well as the departmental website before the commencement of the counseling session on the next day. Then, my lords, 20. Procedure. The initial appointment of candidates, my lords, I'll skip it because
may not be
yes.
applicable.
Then 18, then 20. Competent authority concerned shall ensure that above rules are scrupulously followed while effecting the transfers. Now, may I just pass on this convenience compilation minutes? Just pass it on.
An amendment ಇದೆ ಓದ್ಬಿಡಿ.
All these
ಹೌದಾ?
things arise because there are
ಏನು
vacancies.
ಅದು critical way. Lots.
ಹೌದು ಅವಾಗ ಈ ಪ್ರೊಸೆಸ್
ಇದು
ಟ್ರಾನ್ಸ್ಫರ್ arises in vacancy, actual or contemplated movement. ಅದನ್ನು ಬರೀಬೇಕು ಅವರು ಅಲ್ಲಿ ಇಂಪಾರ್ಟೆಂಟ್ ಅಲ್ಲ ನೋಷನಲಿ they have to work out these are the
How the vacancy list is prepared?
Let's now, the vacancy list was prepared. Let's I have produced, kindly have a look at the convenience compilation which I have given now. I have prepared a synopsis.
Lots, one submission. While act and rules have been read, there is one amendment that also can be read.
amendment.
Yes.
Please, act amendment to the rules, which is relevant for this case. So I just given a copy also, secondary.
ಇವನ್ನೆಲ್ಲ ಗೆಜೆಟ್ ಪಬ್ಲಿಕ್ ಅವೈಲೇಬಲ್ ಇರಂಗ್ ಮಾಡಿರ್ತಾರೆ.
They are aware of it. They are aware of it.
ಏನು ಡಿಫರೆನ್ಸ್ ಏನಾರ ಆಗಿದೆಯಾ?
Let's say that we have introduced, my lords, and amendment to rule 2, a concept of critical vacancy.
ಕ್ರಿಟಿಕಲ್ ವೇಕೆನ್ಸಿ
Critical vacancy.
ಏನದು?
My lords, critical vacancies. my lord,
my lords,
I'll just read, my lords. There are multiple categories we are given. My lords have 2 AA, my lords, AA. Critical vacancy means and includes such of those vacancies in any cadre which in the exigencies of administration in the best interest of public health and family welfare service government cannot afford to perpetuate the same, namely newly created post in any government hospital or government institution, or whenever there is change in the staffing pattern in the government hospital or government institution providing for sanction of additional staff either by creation or by transfer or redeployment as the case may be, where more than 50% of the sanctioned posts are vacant in any government hospital or government institution other than a primary healthcare or subcenter in non-category C districts. In case of C category districts, more than 40% vacancy shall be deemed to be critical vacancy. Then,
ಏನ್ ಹೇಳ್ತಾರೆ ಅವರು?
then this is important.
What they say?
My lords, in the event, there is if 50% of the sanctioned posts, my lords, in a particular area, that is in non-category C districts, 50%, my lords, there are sanctioned posts are vacant. Then there are critical vacancies. I need to fill it up on priority. Then, my lords, in C category, it is 40%, my lords. That out of, suppose there are 10 posts and I have only 4 people manning the post, there are 6 vacancies. Then, my lords, this is important.
absence of,
ಇಂಥ ಪ್ರಾವಿಷನ್ ನಮ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಜಡ್ಜಸ್ ಮಾಡ್ಬೇಕಿತ್ತು. Because our court worked below 50% for years.
please, around
Yes.
absence of one or more specialists among the team of 3 specialists, that is OBG, obstetrics and pediatrician, anesthetist, who are very much essential for providing proper care to mother and child health in government health or government institution. This is, my lords, we have 3 specializations, which is for providing proper care to mother and child. Out of 3, if, my lords, there are more than one specialist which is absent, if I have, they are called triad vacancies, we use the word triad. If all the 3 are there, then I can give, my lords, proper care to mother and child. If even one is absent, my lords, there is an issue with regard to, so therefore, my lords, critical vacancy also includes on priority, my lords, filling up. If suppose there is 2 vacancies or 1 vacancy in that, first I fill up the 1 vacancy so that there is a triad, at least I can provide the services there. That is how it is done. Please, my lords.
Yes.
So this is
What, how are you structuring your submission?
Amendment Rule 6 also, your lords, may kindly see, my lords.
Rule 6
Same in the amended rules.
amended.
ಇದು ಸ್ವಲ್ಪ
Rule 6
Provide-
amends Rule 11.
rules, yes, amendment of Rule 6.
Amendment
Lords,
of
Rule 4, my lords, Rule 4 of this amendment
of Rule
rules,
6.
which amends Rule 6.
After the claim.
Provided that the period of stay at a place specified above is not applicable to mutual transfers. Husband and wife transfers, request transfers in case of terminally ill, widow, physically disabled. Mutual transfers.
Correct.
That's what happens in mutual transfers. It becomes a.
ಅವ್ರಿಗೂ ಬೇಕು ಇವ್ರಿಗೆ ಬೇಕು ಇಶ್ಯೂ ಆಗೋದೇ ಇಲ್ಲ ಅಲ್ಲಿ.
ಅವ್ರಿಗೂ ಬೇಕು ಇವ್ರಿಗೂ ಬೇಕು. ಈಗ ಬೆಂಗಳೂರಲ್ಲಿ ಹೆಂಗ್ ಮಾಡ್ಬಿಡ್ತಾರೆ ಅಂದ್ರೆ ಬೆಂಗಳೂರು
ಅವ್ರವ್ರಿಗೆ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ.
ಬೆಂಗಳೂರು ಅರ್ಬನ್ ಅಲ್ಲಿ ಹೇಗ್ ಮಾಡ್ಕೋತಾರೆ ಅಂದ್ರೆ ಇವ್ರದೇ ಸರ್ಕ್ಯುಲೇಷನ್ ಚೈನ್ ಜಯನಗರ್ ಟು KC ಜನರಲ್, KC ಜನರಲ್ ಟು ಜಯನಗರ್.
So this should be worked in such a way that a cartel is not formed.
Is not found.
ಆ ರೀತಿ ಮಾಡ್ಬೇಕಾಗ್ತದೆ.
That is
Otherwise
essentially-
ಇವರಿಬ್ರು
Yes,
that's what is the intention.
That
Now,
is-
mutual transfers ಅವರು connected matter ಅಲ್ಲಿ ಇದ್ದಾರೆ. They want a mutual.
This is the whole difficulty with which we are facing. Now, the persons who are cases of mutual transfers, if such an elaborate process was provided for the purpose of ensuring that everything takes place by counseling, Act is silent about exemption of the mutual transfers.
So mutual transfer ಇರಲೇಬಾರ್ದು ಅಂತೀರಾ?
Mutual transfers, it may be far-fetched for me to say that. No,
Any
I will not
service,
say that.
service
Requires.
mutual transfer.
I will not say, but
Without affecting
yes,
the
now
fit and substance or the
of-
policy content.
of the,
of the
now
statute.
what happens? If let us assume that these are the vacancies which are available. A person by computation of the total number of years which he has spent in zone A, if he is required to be transferred and he is required to go to a rural area and there is another similar officer, they give mutual transfers. This unguided mutual transfer leads to difficulty. I can understand if mutual transfer is happening within zone A only. Only Bangalore urban it happens.
That cannot.
That can't happen. I can understand. If zone A goes to zone C, zone C comes to zone A, then there is some consideration.
But see.
Only zone A officers want to run around milords in zone A.
No, kindly see, it is a proviso.
Yes.
Proviso, the Supreme Court said,
It
is
doesn't
an
cut-
exception
Yes.
to the rule which is incorporated above.
Yes.
So without offending the
The
inner
substratum of
voice
the
of
rule.
the rule.
Rule. Proviso has to be
To follow
considered.
that.
Yes.
That's all.
That's the reason.
Otherwise, it has abundant abuse potential,
Yes.
as you rightly said.
That's essentially the case belongs before your lordships. We are in a position to demonstrate the kind of abuse which has taken place. If the government was only fair, they would have placed before the court the number of mutual transfers which they have facilitated. And in what zones. This data would have brought to the fore as to what and in what manner the mutual transfer is being either used or misused.
This appears to be.
If this is the contention being put for
That's
the
not
first
the
time,
first
it is not
contention.
pleaded.
ಅಲ್ಲ, ನಮ್ಮಲ್ಲಿ ಹಿಂಗ್ ಆರ್ಗ್ಯೂ ಆಯ್ತು ಹಿಂಗ್ ಆರ್ಗ್ಯೂ ಆಯ್ತಲ್ಲ.
ಇಲ್ಲ,
We
ಹಂಗಲ್ಲ.
are all participatory process. ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀರಿ,
Please,
ನಾವು ಜಡ್ಜಸ್ ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀವಿ.
please, lords, but this is not their case. This was not pleaded either before the KIT or before in the previous date of hearing. This is for the first time. He is coming up.
Your
with
case.
his-
It's there.
ah.
The issue of rule fix has no application in this case. Because they have embarked upon our field, the advantage of this coming for this because they have mismatch, their logo is fixed only in group section 5 and group 5. Section 6 and group 6 is with regard to the process of public interest. Because mismatch is mandatory in that. Because they are not holding the specialization and treating the patient of a specialized category. They are like mismatch with other categories. They are required to shift to the specialization in which they hold under section 5. For that, what is the procedure is contemplated under 5 only. 6 has no.
Not 6 at all.
Now, that's what happens. It is something like this. Let us assume there are 100 specialists and super specialists. The mismatch can be accommodated till 40. The remaining 60 will be there. What should happen to them? It is not that they are required to get stagnated in the same places.
Perhaps then they travel to 6.
That's the reason. There they travel to 6. That's what he wants to contend is, if specialty and super specialty you fall under that category, then you are not entitled for transfer under counseling process at all. That cannot happen. These are limited mismatch categories. I will not dispute. First, they will accommodate mismatch.
I feel there are certain inarticulate premises on which statutes are made.
Yes.
One inarticulate premise is everybody should undergo transfer.
Yes, please.
Though in so many words, section does not say.
True.
That's how it is structured actually. Subject to exceptions.
Yes.
How rules relating to exception should operate, because that also has to be normative.
Yes.
That way we have to approach the matter. Nobody can say, I cannot witness, or I will remain in Joe A only.
But therefore, they have fixed the minimum tenure. Minimum tenure for group A post is 3 years. So even if it is not 3 years, in cases of mismatch, even that 3 years will not be applicable, because 3 years should be construed, as I could understand from the rules.
In the light of admissible.
Yes, in the light of a mismatch circumstances, even if it is not 3 years, he is entitled to go and sit in the post which is meant for his specialization. There, if he completes 3 years, then he gets liable for transfer. But then again, one more specialist only will have to come and sit there. The whole object of this act and the rules is to ensure that the specified posts for the specialist should be circulated only amongst the. That's the reason why it said the moment the act comes into force, you will have to ensure that this mismatch is addressed. Not this is an act of 2011. We are in there 2024. Even now they are handling mismatch for various reasons.
Any vested interest in the
Without which it cannot happen.
Mismatch concept.
No, my lords, in fact, we had made a statement in the previous dates of hearing. It is recorded that from the time the act has come into force.
Who heard this matter?
My lords, it was heard by Court Hall 3, my lords, Justice.
Why did you not tell it in the beginning itself? We'd have sent it there only, instead of reinventing the wheel.
Lords, the other, even it was heard during the vacation bench also, my lords. So it has been heard across. No, my lords, much water has flown as on date, my lords. My lords, if my lords see the cost title, their grievance, my lords, is only this. It is, I would rather put it this way. The modus operandi is, my lords, for every year we are having a counseling. Till date, from the time the act has come into force, the entire process of counseling from the stage of mismatch to rural mismatch and then, my lords, to public interest, we have not been able to complete because one or the other litigation. The idea is this: you file a case, you stall it, some or the other legal ground is advanced.
No stalling, we will pass the judgment.
My lords, in fact, what had happened was their entire grievance before the KSAT was this: mismatch list was published. They were saying mismatch and public interest has to be held together because the pool that is available to me to choose from is being reduced. So thereafter, my lords, the tribunal disposed of the matters, directing us to finalize the list.
Officer,
please, one of them.
Ask him to sit down. Why he should stand? Sit down beside in that vacant. When lawyers come, you have to yield place. That's all.
No, my lords. After the disposal of the matter before the tribunal, the mismatched counseling, my lords, was scheduled to be held. At that stage, my lords, they approached this honorable court. Their entire grievance was, I go into the mismatch counseling. I will be, the choice that is restricted to me is very little. Thereafter, I will not be able to participate in the public interest counseling. Then court felt that after reading the scheme of the act, that restricting them only to the mismatch might not be correct. But since that is a procedure that being followed, court said an interim order was passed that the petitioners will be allowed, notwithstanding a choice that they would have made in the mismatch counseling, to participate in the further rounds of counseling. what we did, my lords, was not only to the petitioners, we issued, my lords, a circular stating that all the persons who participate in the mismatch counseling will also be permitted to participate in the public interest counseling, because we had to extend it. Thereafter, my lords, we have published one more vacancy list for the purpose, my lords, of the public interest counseling. We issued one more circular where in the public interest counseling, what we did was we said that the mismatch persons will be entitled to choose a post first, thereafter the public interest counseling. That circular was challenged by Sarthi's clients, my lords, before the KSAT. And their interim order was not granted. He came up before this honorable court stating that in the public interest counseling, mismatch again should not get priority. Now that their choice was, they have already participated in the mismatch counseling, they should yield to the priority list. So that, my lords, the court felt, my lords, that was the right legal position. We also considered to that. So therefore, my lords, an order was passed that insofar that we can go ahead with the public interest counseling, in the persons who participate in the mismatch counseling will be permitted to participate in the public interest counseling seriously on priority. And, my lords, several contentions, all these contentions with regard to competent authority, other things were advanced. Court said strictly go as per the act and the rules. Then, my lords, we finalized a provisional vacancy list, a provisional, my lords, priority list. That was published, my lords, during the vacation. Then they moved the vacation bench stating that filing an IA number 8 of 24 stating that seeking for stay of that provisional list. Then, my lords, we said we'll file objections to that. In the meantime, we'll also consider the objections to the vacancy list and the provisional list and place it before the court, take leave of the court and proceed. Now, my lords, we have considered all their objections. If my lords see the cost title, there are around 8 to 9 of them. All of them, my lords, are working in urban areas. Kindly see the cost title for a moment. My lords have 18980.
Shashidhar is in Kanakpura.
Kanakpura.
Dr. Shashidhar. Dr. Sunil Kumar is in
Kadur.
Chitradurga. Challakere.
I can assure one thing that none of them are in Bangalore.
Yaru Bangalore.
It's not in Bangalore. The next petition, the other person is in Hassan and Hiriur and Kalburgi, my lords.
But none of his clients are in Bangalore.
No, lords, it's not about Bangalore. If they want to come to Bangalore, their grievance, my lords, is that we have restricted it to 15% is the discretion that has been given to the state government, the competent authority here. 15% is the maximum limit to which I go.
50%.
15%
What is
of the working strength. My lord, suppose
that 15% is in your absolute discretion.
Maximum limit is 15%.
Lords, can I?
One sec, I'll just.
Amendment. 2017 amendment.
Please, my lords. Maximum limit, my lords, earlier it was 5% of the working strength. Working strength, my lords, if the Carter strength is 100 and I have working strength, my lords, of 70, then my lords, I have to restrict it to 5%. The transfer will be restricted in a year only to 5% of 70.
Now it is 15%.
Now, my lords, we have amended it because what used to happen was, even I'll just show the priority list. The top person, my lords, has worked for their persons, my lords, who have completed 10 years. But I have persons who have completed 15 years and more, who will be top in the priority, who will take a choice, and they will get Bangalore and other posts. Suppose I exhaust that 15%, then, my lords, they will even not get a choice. But in the meantime, they will, because they are mismatch vacancies, if suppose they were not mismatch vacancies, they would continue to occupy the post. Since they are mismatch, they obviously have to yield because you are not a specialist there. But that is the first object, my lords. Mismatch, my lords, is a grave thing because if a specialist, you are trained as a pediatrician, in all probability, it would have been an in-service where the state government would have, and now if you are sitting in a post of a general surgeon, neither can you operate there, nor can you work here also. And this is the mischief.
What happens, I just wanted to say this. So far as compulsory transfers to mismatch is concerned, the 15% bar is not applicable. Kindly have a look at section 5.
Section 5.
Yes.
Unamended.
It is applicable to public interest transfers, which takes place through counseling. Lords, whatever is being said, Lords, there are two processes. Let there be no confusion, Lords. The whole object was to ensure that there is no mismatch. Other than rural areas, the transparency, etc., the whole object is to ensure that there is no mismatch of the specialists. The resources are not wasted in wrong places.
Correct.
Now, section 5. No specialist. Kindly, Lords, the caption is compulsory appointment or transfer or promotion of a specialist or senior specialist. It's compulsory. Page 5 of the Act and Rules. No specialist or senior specialist, postgraduate degree, diploma shall be posted or transferred to work in a post which is not identified as a specialist.
So he should
post.
work only in identified specialist. post
Notes,
only.
therefore, notes, section 5 does not contemplate a scenario where public interest transfers. Section 6 is public interest transfers.
Correct.
Notes, what they are now doing is they want to mix up both the lists, which is not permissible.
No, what 2017 amendment?
2017 amendment is the rule, section 6 was what was amended. Kindly have a look at section 6. Section 6. Notes, page number 2, your lordships may kindly see, notes. Public interest transfers alone is restricted to 15%. Notes, what they are now wanting to display before the court is, we will merge both compulsory transfers and also the public interest transfer and plug it at 15%.
No, we're not saying
that. If that is not what they are saying, then their list gets exhausted. Then 15%, milords, will be the total number of vacancies which will be available, which has to be notified. They have not done it. I'll demonstrate.
Okay. Yes, let us articulate your grounds now.
Please,
In
milords.
the light of your submission.
Lords, may kindly have
What is the wrong with the tribunal's order?
Milords, kindly have a look at that. Convenience
Your friends
compilation.
can go for a coffee round. It is 12 now.
Yes, milords.
It will take some more time. Once for all, we want to dispose of.
Please, please.
Lords, may kindly take that convenience compilation which I have given now, milords.
Convenience. ಎಲ್ಲ ಕೇಸಸ್ ಸ್ವಲ್ಪ ಇನ್ಕನ್ವೀನಿಯಂಟ್ ಇರ್ತಾವ ನಮ್ಗೆಲ್ಲ. Yes.
The circular dated 15/6/2024, this is number 1, issued by the second respondent, notifies only 140 specialists under the mismatch category.
Never transferred.
Then there are numerous specialists working under the mismatch posts who are never subject to transfer by counseling. We have given the names of 43 of such specialists, which is forthcoming at paragraph number 3, page 43 of our writ petition. Kindly take the writ petition, I'll just straight away draw your lordship's attention to both the annexures. Page number 43. These are compulsory transfer. They should not be held there. The moment they are transferred to those posts, these posts are falling vacant, milords, for being filled up through the public interest transfer, subject to the block of 15%. Page 43.
How many of them?
Milords, para 3, milords, it is submitted that out of 6,100 doctors, 43 are there.
Even doctors are 40.
At page 47. Notes, what we are now giving is
ಇವರೆಲ್ಲರೂ specialists.
Yes, mismatch specialists. Notes, what happens? These are compulsory transfers. The whole problem is now they will have to notify all the posts.
Mismatch means the specialization.
Milords, my specialization is something, I'm working for something else.
That post is not available.
It's not available. Milords, this is very disastrous actually. Very disastrous.
It's
very, very disastrous.
ಹಂಗಾಗ್ತದೆ. ಆಮೇಲೆ ಹಾರ್ಟ್ ಸರ್ಜರಿ ಅವನು ಹೋಗಿ ಇಲ್ಲಿ ಕಿಡ್ನಿ ಕಡೆ ಕೊಡ್ತಾನೆ. ಕಿಡ್ನಿನೂ ಫೇಲು, ಹಾರ್ಟು ಫೇಲು, ಎರಡೂ ಆಗ್ಬೋದು.
ಅದನ್ನೇ ಹೇಳಿದ್ದು.
Not know much about kidney. Heart specialist will not be, he will be knowing, but he will not be knowing much about kidney.
Yes.
The nephrologist will not be much knowing about the heart.
Yes.
So both they may together operate a brain also.
Yes. Milords,
Anything may happen.
I was telling him that a forensic doctor and a surgeon should not be a mismatch. That a post-mortem doctor is discharging the duties of a surgeon because he knows the white cut.
So how you are addressing this issue?
My lords, this issue, my lords, was in fact, my lords, if my lords see the order sheet, this aspect, my lords, was
No,
addressed.
mismatch is a disservice to the
It
society.
is a disservice, my lords. In fact, we don't want, in fact, on this, my lords, I had made submission that if my lords see page 43 for a moment.
Yes, 43, I have seen them, 1 to
43.
8
Please,
mismatch,
please, my lords,
9 to 17 mismatch, totally it runs to 43.
Please, my lords, they had given these comments in respect of serial number 3, 4, 5, my lords, they are administrative posts.
We'll exclude THOs, my lords.
3, 4, 5, all right.
We'll
Let us
exclude-
leave that.
I will just show, my lords. 3, 4,
40
5
remain.
3, 4, 5 is administrative post. 6, 7, 8,
Or ಬರ್ತಾರೆ, chief medical officers.
3, 4, 5
administrative post.
ADM.
Then, my lords, 6, 7, 8 is autonomous post. They're deputation post, my lords.
No.
They're HFW, they don't come under our jurisdiction.
In your,
Lords,
They are not
that's-
in
that may
your
not be a
control.
correct statement. Let him take instructions. That may not be a correct statement. Let him take instructions.
Lords, in fact, we can file an affidavit on this, but I'll just make my submission based on.
6, 7, 8,
6, 7, 8. my
up to Dr. Supriya.
Please, my lords.
They are,
My lords, deputation posts, autonomous institutions.
ಎಲ್ಲಿಂದ
My
deputation?
lords, this is Hassan Institute of Medical Sciences. It is an autonomous institution, my lords. Under the Department of Medical Education. We are, my lords, Department of Health and Family Welfare.
Vijayanagara.
6 is, my lords, may kindly say General Surgeon, Hassan Institute of Medical Sciences.
These are from deputation.
These
They
are
have gone on deputation.
gone on deputation, or they are autonomous institutions, my lords. They don't come under the control of the Health and Family Welfare.
Then they will be safe there. Can you exclude them that way?
Our separate department, my lords, earlier, Department of Health and Family Welfare, we had medical education under us. Now, my lords, all the medical education, there is a separate department, my lords, of medical education, and all the autonomous institutions
Come under that.
come under that. BMCRI, Institute of Medical Kidwai, and Manda Institute of Medical Sciences, and all institutes, each district, my lords, we have an Institute of Medical Sciences.
Lords, IA number 8, page number 75. That statement may not be correct.
So they will be permanently there only.
Please, my lords,
They will be,
please.
because they are complete an island. No rules apply to them.
Our employees separate.
Huh? It cannot be beyond 5.
May,
Can 5.
Lords, may just, this is very this is not a correct statement. By a notification dated 27/8/2024, this position is clarified. Lords, kindly have a look at Annexure
Saying?
M. My lord, saying, I just read this. Annexure M, page 75, along with IA number 8 of 24. IA 8 of 24, page number 75.
Page number?
75.
ಪ್ರಕಟಣೆ.
ಪ್ರಕಟಣೆ 27/8/2024. ನೋಟ್ಸ್ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಆರೋಗ್ಯ ಮತ್ತು ಕುಟುಂಬ ಕಲ್ಯಾಣ ಇಲಾಖೆಯ ವೈದ್ಯರು, ತಜ್ಞ ವೈದ್ಯರು ಮತ್ತು ದಂತ ಆರೋಗ್ಯಾಧಿಕಾರಿಗಳು 24-25ನೇ ಸಾಲಿನ ಸಮಾಲೋಚನೆ ಮೂಲಕ ವರ್ಗಾವಣೆ ಮಾಡುವುದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1ರ ಸುತ್ತೋಲೆ ಪತ್ರಗಳ ಅನ್ವಯ ಮಾರ್ಗಸೂಚಿಗಳನ್ನು ಹೊರಡಿಸಲಾಗಿರುತ್ತದೆ. ಉಲ್ಲೇಖ 2ರ ಸರ್ಕಾರದ ಆದೇಶ ಕ್ರಮ ಸಂಖ್ಯೆ 9ರಲ್ಲಿ ವೈದ್ಯಕೀಯ ಶಿಕ್ಷಣ ಇಲಾಖೆಯಡಿಯಲ್ಲಿ ಬರುವ ಆಸ್ಪತ್ರೆ ಮತ್ತು ಸ್ವಾಯತ್ತ ಸಂಸ್ಥೆಗಳಲ್ಲಿ ಆರೋಗ್ಯ ಇಲಾಖೆಗೆ ಮಂಜೂರಾದ ಹುದ್ದೆಗಳಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಆರೋಗ್ಯ ಮತ್ತು ಕುಟುಂಬ ಕಲ್ಯಾಣ ಇಲಾಖೆಯಲ್ಲಿ ಎಲ್ಲಾ ಅಧಿಕಾರಿ ಸಿಬ್ಬಂದಿಗಳನ್ನು ನಿಯಮ 6ರಂತೆ
They are also brought within.
they are also brought within the purview. They cannot. Now we have kindly have a look at page number 77. This is the list of 177 posts which is brought within. I have produced the entire list.
List includes those on deputation to
Lords, those-
autonomous institutions.
These are all the HFW sanctioned posts. Lords, next page, my lords. ಆದುದರಿಂದ page 76. ಆದುದರಿಂದ ನಿರ್ದೇಶಕರು ವೈದ್ಯಕೀಯ ಶಿಕ್ಷಣ ಇಲಾಖೆಯವರು ನೀಡಿರುವ ವೈದ್ಯಕೀಯ ಶಿಕ್ಷಣ ಇಲಾಖೆಯಲ್ಲಿ ಬರುವ
All information should be furnished.
ಅದನ್ನ ಇವ್ರು ಫರ್ನಿಶ್ ಮಾಡಿದ್ದಾರೆ. ಪೇಜ್ 77 ಅವ್ರ ವೆಬ್ಸೈಟ್ ನಲ್ಲಿ ಇದೆ ಇದು. These are the 177 posts. This entire list is eschewed, my lords, by including it in the provisional list.
Yes.
So that statement, my lords, may not be correct too.
After, at least after issuance.
At least after issuance of this
this,
notification of 27/8/24.
Issued by whom?
Lords, this is issued by
ಆಯುಕ್ತರು
Lords,
ಆರೋಗ್ಯ ಮತ್ತು ಕುಟುಂಬ.
Competent authority.
Health and Family Welfare.
ಆಯುಕ್ತರು ಆರೋಗ್ಯ ಮತ್ತು ಕುಟುಂಬ ಸೇವೆ ಸೇವೆಗಳು.
On 18/7/24, when the petition was filed, Lords, when the first round of counseling took place, with regard to mismatch counseling, only the mismatch counseling, their allegation, my lords, was all these posts were left out, and this was issued, my lords, subsequently on 27/8.
To
Therefore,
address his grievance.
that was his grievance. Therefore, we made a submission that since when you participated in the mismatch counseling, these posts were not available to you, but now by 27/8 it is available. You are permitted to participate in the public interest counseling. And now, my lords, in the list that we have placed before this honorable court, these posts are available. As on that day, my lords, it was not there. That is the answer we had given to the court.
Lords, this list of what they now say is the counseling list.
Lords,
This does not include 177 posts.
Lords, may I just make this submission? Lords, after we published the provisional list, they came before this honorable court. Vacation bench of this honorable court, my lords, passed an order permitting us to consider their objections, consider, my lords, the averments in the IA number.
Then you have issued this.
Then, my lords, the court permitted us to issue a final list, finalize the final list, place it before the court. We have not published it. Final list is before my lords, which was given to them on 29th of October 2024. And final priority list is also after that. 1 month, almost 1 month, my lords, they're not saying in the final list what other posts they want. If they want it, I can, instead of all this, they just don't want the counseling to go on.
ಈಗ ಅವ್ರು ಎಲ್ಲೆಲ್ಲಿ
Lords,
ಬೇಕು ಅಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿಕ್ಕೆ ರೆಡಿ ಇದ್ದೀರಾ?
Allala.
May I just,
They have to
Lords, I'll just,
My lord, they have to participate in the counseling. Priority bandre barutte. If
I'm
by
not
that
asking
time, my lord,
anything
the
beyond
court
it.
get exhausted, their only grievance is, I am leaving out certain posts. Let them make a list and give it straight away, my lords, today
But I-
itself. I will come before the court. Why it is not included? It is not included. They should say it.
now I'm making a
Place the final
statement.
list.
Now I'm making a statement. The list which they say is prepared after consideration of all the objections and also placing this page number 77 on record is a list which they have given us saying that all these 177 posts are not included in the counseling. I'm just passing. This is the list. This is the list.
When I publish the final list, they should, my lord,
ಇವರೆಲ್ಲರೂ ಇನ್ಕ್ಲೂಡ್ ಮಾಡ್ರಿ ಪ್ರಾಬ್ಲಮ್ ಬರಲ್ಲ ಅಂತ.
lords, that is what we are saying.
ಅಷ್ಟೇ ಕೇಸ್ ಇರೋದು. ಬೈ ಅಂಡ್ ಲಾರ್ಜ್ ದಟ್ ಇಸ್ ದಿ ಕೇಸ್.
Lords, my lords, this honorable court has directed us to place the final. Lords,
We do to our judicial office. Now we include everybody.
please,
ಎಲ್ಲರನ್ನೂ include ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ
Lords,
ಈ
I have-
ಪ್ರಾಬ್ಲಮ್ ಬರಲ್ಲ.
Lords, I have placed
ಹಾ.
before my lords, by way of a memo, the priority list also, the vacancy list also.
230 ಕರಿತೀವಿ ಬೇಗನೆ ಹೇಳಿ ಏನು ಅಂತ.
I have placed before my, it is before my lords already, that was
Fine
placed
now.
29/10. And now, my lords, in where that list, they should say, this is excluded. 1 month has passed by, they have not said anything. Now today they are making this argument. If they had just given us a memo stating that the following posts have not been included, I would have just come before this honorable court saying yes or no. Yes, idre olagagtu counseling ಮಾಡ್ಬಿಡ್ತೀವಿ ಸ್ವಾಮಿ.
Lords,
ಅಷ್ಟೇ.
I have
Tomorrow,
given
let
them
him have it tomorrow.
morning itself.
No, it's all right.
Morning. Lords, this issue requires to be resolved. There is not an adversary litigation here.
Our patience is enormous,
Yes,
really.
I
That
know
one
that.
you have taught us.
yes.
But patience of people sitting behind you,
May not be.
you may run the risk. And
Yes.
the word you is a plural in English. You is singular, you is plural.
Yes. My lords, that convenience compilation, which I have now passed on to your lordships, which I was reading,
You
I have
have
shared
it.
it. Yeah, I have shared it with my learned
Lords,
friend.
it should be with reference to the final list. Convenience compilation, my lords, from it starts, my lords, even first day indane ಏನೇನು ಇದೆ ಎಲ್ಲ.
ಈ ಡೆವಲಪ್ಮೆಂಟ್ ಇಟ್ಕೊಂಡು ಹೇಳ್ರಿ ಏನ್ ಮಾಡ್ಬೇಕು.
No, it is not inclusive of the.
Lords, what I am saying is this. I have placed, my lords, the final list, vacancy list and priority list. That on the basis of which I am going to hold counseling. Seeking the leave of the court, my lords, to proceed further with the counseling. If according, that was filed 25 days back. If according to them, any post has been left out in that or any post has to come, let them give me a statement by end of the day, my lords, or tomorrow. I will make a statement whether it can be included, cannot be included. And if it has to be rectified, I'll rectify it, my lords, and take permission of the court and go ahead with the counseling. That is the simple
I've given it.
ಅವ್ರಿಗೆ help ಕೊಟ್ಬಿಡಿ.
I've
ಇಲ್ಲ,
given the
not
list.
this, my lords, this convenience
No,
compilation.
let him go through. Let's let him go through. Convenience compilation is essentially indicating these are the posts which you have not included.
This is
I'll give it.
ಕೊಟ್ಬಿಟ್ರೆ ಆಯ್ತು.
ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ ಅವ್ನು.
ಲಿಸ್ಟ್ ಕೊಡಿ.
Lords, this convenience compilation that they have
ಇದನ್ನಲ್ಲ,
given.
ಇಡಿ, ಇನ್ನೊಂದು ಲಿಸ್ಟ್ ಕೊಡ್ತಾರೆ.
ಇನ್ನೊಂದು list ಕೊಡಿ, sir. Let
ಇನ್ನೊಂದು
them
list
say-
ಕೊಡ್ತೀನಿ ಅವ್ರು ಯಾವ್ದಾವ್ದು ಸೇರ್ಸಿಲ್ಲ ಅಂತ.
Let it not be argumentative. I just need the list of the
That's all.
post you
That's
want.
But by nature, Indians are argumentative, says Amartya Sen.
Argumentative.
Itself is argumentative
Argumentative,
Indian.
yes.
That was in a different sense. He
Let's-
mentioned about Adi Shankara.
And now, as a matter of fact, what they are required to do, we really fail to understand even today, Why the mismatch is not addressed?
ಅಲ್ಲ, ಈಗ ಕೊಟ್ಟಿಯವ.
No, let them,
Come tomorrow.
a statement was made
Ah.
that they were conducting counseling every year. That's not correct.
No, no, we
For
were not
this-
able to conduct.
1 minute, let me complete. For 8 years, they have not conducted the counseling. The whole difficulty arose because, my lords, what happens? 8 years if counseling is not conducted, there are only transfers which are effected through the political modules.
ಹಂಗ ಅನಿಸ್ತದೆ ಮಾತ್ರ.
That is all what was operated.
8 years, we were not able to complete all the counselings. Mismatch was started, then my lords, there was some
No,
issue, then we were not able to complete, there was litigation also.
ಇಲ್ಲ.
My lords, our intention was to complete the counselling this year, at least for the entire gamut of counselling. Mismatch, public interest.
ಮ್ಯಾಚ್ ಫಿಕ್ಸಿಂಗ್ ಇಲ್ಲ ಇದರಲ್ಲಿ.
ಇಲ್ಲ sir. ಅದೇ
ಅದು ಇದೆ, ಆ ಎಲಿಮೆಂಟ್ ಇದೆ, ಆ ಎಲಿಮೆಂಟ್ ಇದೆ.
We want to do it, my lords, as transparently as
Anyway,
possible.
ಈಗ ಲಿಸ್ಟ್ ಕೊಡಿ ನಿಮ್ದು.
I'll give the list.
ಕೊಟ್ಟಾಗಿರಲ್ಲ ನೆಟ್ ಮಾಡಿ ಹೇಳಿ.
If they give me
ನಾಳೆ
the list,
ಕರೀಲಾ?
tomorrow, my
Lots
lords,
ಹಾ,
or
tomorrow.
Monday, my lords.
Monday.
ಅಲ್ಲ, list ನನಗೆ correct ಆಗಿ let them
Monday.
give the proper list. Otherwise,
ಮಂಡೇ.
Please, Phil.
ಮತ್ತೆ ಈ ರಿಪೀಟ್ ಮಾಡಂಗಿಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್.
ಇಲ್ಲ, ಇಲ್ಲ.
Our list ಕೊಟ್ರೆ, I will come back with a solution and it can be closed.
ಮುಗಿದೆ.
Please.
ಮೋಸ್ಟ್ ಆಫ್ ದಿ ಪ್ರಾಬ್ಲಮ್
ನಾನು ಅವ್ರಿಗೆ 10:30ಗೆ ಹೇಳಿದೆ,
ಜೊತೆ
ನಾನು
ಕೂತ್ಕೊಂಡು
ಸೊಲ್ಯೂಷನ್ ಹೇಳ್ಬಿಡಿ, ನಾನು ಏನು ಆರ್ಗ್ಯುಮೆಂಟ್
ಈಗ
ಮಾಡಲ್ಲ ಅಂತ.
ಗವರ್ಮೆಂಟ್ ನಮ್ ಕರೀಲಿಕ್ಕೆ ಆಗಲ್ಲ.
Please.
ಗವರ್ಮೆಂಟ್ ಅಂತ ಐಡಿಯಲ್ ಎಲಿಮೆಂಟ್ಸ್ ಎಲ್ಲ ಉಳಿದಿಲ್ಲ ಈ ಗವರ್ಮೆಂಟ್ ನಲ್ಲಿ. ಏನೇನೋ ಪ್ರೆಷರ್ಸ್ ಪುಲ್ಸ್, ಪಾಪ ಅವ್ರಿಗೆ ಏನೇನ್ ಸಮಸ್ಯೆ ಇದೆ ನಮಗ್ ಪೂರಾ ಅರ್ಥ ಆಗಲ್ಲ. ಏನೋ ನಮ್ ನಡುವೆ ಒಂದು ರೋಡ್ ಹೆಂಕೋ ಹೋಗಿದೆ, ಕಂದಕ ಹೋದ ಇಲ್ಲೋ ಗೊತ್ತಿಲ್ಲ. ನಮ್ ನಡುವೆ ಅವ್ರ ನಡುವೆ ಒಂದು ದೊಡ್ಡ ರೋಡ್ ಇದೆ ಬಹಳ ವರ್ಷದಿಂದ. ಅದು ಮತ್ತದು ಸಿಮೆಂಟ್ ರೋಡ್.
And it is also
This is the only
Concrete road.
ಹಾ,
And
no, concrete road.
and it is
Reinforced steel concrete road.
Smells.
ಹೌದು.
ಕೆಳಗೆ
and it is named
ಕಂದಕನೂ ಇದೆ.
Dr.
ಕಂದಕ ಇದೆ,
Ambedkar.
ಹೌದು. ಕಂದಕ ಇರ್ಲಿಲ್ಲ, ಈ ಕಂದಕನೂ ಬಂತು.
ಇವನ್ನ ಅಡ್ರೆಸ್ ಮಾಡಿ. ಸಿಂಪಲ್ ಇದೆ.
Simple. Therefore,
ಇಬ್ರು ಕುತ್ಕೊಳ್ಳಿ.
we want,
ನಿಮ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇವ್ರನ್ನು ಕರೆಸಿ,
please.
ನಿಮ್ಮ
ನೀವು
ಒಬ್ಬ ಲೀಡರ್ ಒಬ್ಬಿಬ್ಬರ ಲೀಡರ್ಸ್ ಅನ್ನು ಕರ್ಸ್ಕೊಳ್ಳಿ.
ಅವರೇ ಹೋಗ್ತಾರೆ ನಮ್ಮ.
And ensure that they don't keep with them the thigh bone.
Yes,
Thigh bone is the strongest bone in
I
man's body.
understand, my lords.
So keep them away and sit with them and just discuss and come back.
List if they want.
Monday, my lords.
Monday.
Please.
Interim arrangement to continue.
Continue. Grateful.
ಸಾರಥಿ ನಿಮ್ದು ಆಗತ್ತೆ ಮೋಸ್ಟ್ಲಿ ಅದರಲ್ಲಿ. Yes. That will cut. All. Okay. Sorry, we took more time, perhaps for others who are sitting here. Yes.
I appear for the petitioner, my lord.
Yes, please.
This is a petition regarding seeking regularization of service of Group D employee.
Padi.
He was appointed on for a sanctioned post with respect to an existing clear vacancy, and he meets all the 4 parameters defined under the Uma Devi's case. Your Honor, your lordship,
You can call us honor also. This is not, it's not dishonorable.
Your lordship, the question on which the KAT has erroneously dismissed my case is on the ground of delay and laches.
ಇದು
No, the
admission
petition-
ಬಂದದ್ದೇನು ಇದು? Admission
Readings are already completed.
admission.
Readings are
R2 or
already completed.
For R2 or 3.
R2 and R3 are the directors, director and chief administrative officers of the Department of Health and Family Welfare.
You accept notice for them, madam?
Yes, Madam.
Madam Kulkarni, Learned DG is requested to accept notice for unserved respondents as well. Call in second week of February.
My lord, I'm ready to canvass
So you are
the,
ready, but many other matters are there. No?
the short date may be fixed because
All right,
it is on a erroneous ground. His services
Ah,
were not
last week of,
regularized.
January. Okay.
Kindly in the month of December, my lord.
December, very difficult.
And he
Young
has
madam.
certain health
Not-
issues and he has approached the court 4 times
Ah.
before this honorable court. Kindly date may be
This
fixed
time it will
December.
be over.
Kindly a short date in December, Your Honor.
No, December we have difficulty. Yes, next. Seventeen, Venkatesh. ಏನಿದೆ?
Kindly see, my lord, the impugned order passed by the Learned Tribunal relies on a Lordship, my lord, the impugned order at Annexure A, page 28, relies on, my lord, another coordinate bench order. The operative portion, my lord, at page 41. Your lordship will see para 9. In view of the elaborate discussion made in the above cited judgment in 8263 of 2015 on relevant points, we are of the opinion that such judgment is squarely applicable, so on and so forth, my lord, and the application is allowed.
14A cannot be.
ಅಂತ ಫೈಂಡಿಂಗ್ ಕೊಟ್ಟು ಅಲೋ ಮಾಡಿರ್ತಾರೆ. We have approached this honorable court. This honorable court, your lordship may kindly recollect Justice Satish Chandra Sharma bench judgment. Writ petition is allowed. SLP filed by the DGO dismissed. So this is the same matter. But the cause list shows not caveator is there. I may be permitted to serve on him. Your lordship may have it next week. It could be disposed of.
Issue notice. Learned DG is requested to accept notice for respondents. One.
My friend is here.
You accept
File
notice?
already on record, my lord. File
Eh?
Wakalat. The petition copy may be directed to be served on me.
You are for caveator.
But it was last month, but separately I filed Wakalat, my lord, for respond number 3.
Learned AG request to accept notice for respondents 1 and 2. Shri,
Mohan Asim.
so appears for respond number 3. First, call this matter.
Petition may be,
Week of.
petition copy may be.
Pudi,
ಕೊಡ್ತೀನಿ, ಆಯ್ತು ಕೊಡಿ.
Ibrigu Kotpudi. Short point.
Yes, my lord.
Your SLP against the order of Justice Sharma's order,
Not
Satish
my-
Sharma's order.
Yes.
SLP is dismissed.
No, no,
Can this be?
I will, my lord, there is another batch of matters, my lord, which is very same issue is been.
ಇದರಲ್ಲಿ ಡಿಸೈಡ್ ಮಾಡಿದ್ರೆ ಅದಕ್ಕೂ ಅಪ್ಲೈ ಆಗ್ಬಿಡತ್ತೆ. ಅಷ್ಟೇ.
Great.
Pick up the next.
18, my lord. Petition filed by the Lokayukta, my lord.
Yes, Prasanna, ಏನಿದು?
My lord, KT, my lord, allowed the application filed by the delinquent officer and set aside the entrustment order, my lord, on the ground that non-application of mine by the government, my lord, while considering the 12-3 report.
ರಿಮೈಂಡ್ ಆಗಿದೆ.
Remand ಆಗಿಲ್ಲ.
Huh?
If it is remanded, my lord, as per it is covered by the lordship judgment. Here, my lord, it is not remanded.
ಧಾರವಾಡ ಬೆಂಚ್
ಇದೆ, ಇದೆ.
issue notice. Issue emergent notice. Learned AG is requested to accept notice for second response.
Second response. R1 is the delinquent officer. DGU.
Interim order as prayed for.
It has quashed the entire, my lord, entrustment order.
That's
itself.
what.
Please,
But that is covered. See that.
please,
We have
there is a
made one
mention, please,
paragraph.
one paragraph is there, my lord.
Saying
Really,
wherever
Please.
the word remand is
This
not
remand is
used,
not there.
even then shall be treated as remand.
Please,
We have said that.
but-
I am the author of that order.
please, my lord, that observation is there in the judgment. But
That's
however,
what
my
we-
lord, if there is no express order by the KT or by this honorable court, government may not consider.
In
this
fact,
remand.
Venkatesh mentioned,
Please,
in many matters, KAT simply quashes and
Please,
keeps quiet.
please, my lord, many matters.
Then we took care of that.
Please.
I introduced one paragraph.
3 months, blood and otherwise contempt.
Otherwise.
That is also
I
your
said,
lordships are mentioned.
That
My lord, may I make one submission?
Ah.
Serial number 2021 also same issue.
2021,
Please, ma'am.
2021. ನೋಡಿ ಯಾರ್ಯಾರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು. ಕಾಲ್ ಅಲಾಂಗ್ ವಿತ್ 18 ಅಲ್ಲ?
Please, my lord,
18.
Notice
to, my lord,
ಅದು
notice to.
ಜಡ್ಜ್ಮೆಂಟ್ ಕಾಪಿ ಇದೇನು ಶೆಟ್ಟಿ?
ಇದೆ.
ಅದು ಕೊಡಿ. ಎರಡು ಜಡ್ಜ್ಮೆಂಟ್.
ಎರಡಿದೆ. ಅದರಲ್ಲಿ in one matter, my lord, there is locus standi issue was not.
ಕ್ವಾಶ್ ಮಾಡಿ ಕೈ ಬಿಟ್ಬಿಡೋದು. ಮುಂದದ್ ಏನ್ ಮಾಡಬೇಕು ಅಂತ ಗೊತ್ತಾಗಲ್ಲ. ಗೌರ್ಮೆಂಟ್ ಸ್ಲೀಪ್ ಓವರ್ ಇಟ್ ಡಿಪೆಂಡಿಂಗ್ ಅಪಾನ್ ಇಟ್ಸ್ ರಿಕ್ವೈರ್ಮೆಂಟ್. ಅದಕ್ಕೆ ನಾವೇನ್ ಮಾಡಿಲ್ಲ.
And
I wrote.
lordship followed the judgment of earlier Prakash judgment, my lord, wherein
ಪ್ರಕಾಶ್
ಅದರಲ್ಲಿ government is disinterested in, my lord.
to come across several cases where action of local under the provisions of or that of the fault relief has been granted to the delinquent by There are other cases in the order under Rule 14, interest in the exercise. There is no clarity at all whether such cases should be treated as of remand for fresh consideration or outright foreclosure of proceeding. At times of reading such judgments, the stakeholders gathering an impression that proceedings have been quashed once for all, and therefore no remand is made, when a careful perusal thereof indicates the contrary. In a case involving quashment of government order 14A, 14A hoitu andre, matter 12(3) is restored. ಆ ರೀತಿ fold ಮಾಡಿ. Unless the tribunal expressly says, therefore such the highly desired that quashment orders, whatever be the ground, should specifically make it clear and prescribe the timeline for the disposal of remand. We are in times when what is obvious needs to be obviated. Otherwise, judgments may become breeding grounds for injustice. That way we structured it. Please take, give them back. You give on that day when we take up the matter for consideration.
In 2021, notice has to go for R3.
Emergent notice. Note AG accepts notice. Yes.
Oblige.
Copy kodbeku avರಿಗೆ, huh?
Please, we'll take process. Oblige.
Petitioner.
Yes, Joseph.
My lord. The tribunal sets aside the order withholding the increment, my lord, on the ground that the inquiry officer has not conducted the inquiry in an appropriate manner, my lord. Even my respectful submission is in my lordship's judgment rendered in Dharwad. My lordship has covered
So
that.
this also we have to call along with the other matters.
Please,
Issue emergent notice. Learned AG is requested to accept notice for first respondent.
Yes.
And emergent notice to the second. Call along with.
Grateful.
ನಮ್ಮ ಆರ್ಡರ್ ಆದ್ಮೇಲೂ ಹಿಂಗ ಆರ್ಡರ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಇಲ್ಲ ಮೊದಲೇ ಮಾಡಿ.
No, this is prior.
Yes.
My lord, the petitioner is
ಏನಿದು? ಏನಿದು ದಿನೇಶ್?
My lord, the petitioner is working as a selection grade lecturer. According to the ACT notification, which stated that the person who acquires MTech
Speaker.
My lord, according to ACT notification, which states that one advance increment will be given for acquiring MTech degree while in service, and 3 compounded increment for acquiring PhD while in service to the teachers are provided. That is furnished at page number 31 at annexure A1.
Which notification? 2020 or 2016 notification?
My lord, 2010. Kindly turn to page number 31, my lord.
31.
6 and 7.
ಯಾವ್ದದು?
6 ಮತ್ತೆ 7. Teachers in service who have not yet enrolled for PhD
enrolled for PhD.
And therefore derive the benefit of 3 non-compounded increments on award of PhD while in service only if such enrollment with a university recognized by UGC. Point number 6.
All issue emergent. Please learned AG is requested to accept notice for first respondent. First and second, both.
Both, my lord.
Copy put. Next. Yes, Muralidhar.
Lord, Rule 248 of KCSM Lord provides for if a person, my lord, was appointed in a aided institution, my lord, and if he later joins the government service, my lord.
Previous service.
Previous service, 1/4 of previous service have to be counted. Lord, Rule 247A of the KCSM provides that, my lord, if a person has joined service after 36 years, 2 years of service, qualifying service can be added. But in 247A, sub-rule 5, it provides that if a person has been sanctioned the earlier aided service benefit, this has to be given in lieu of that. This 2 years service has to be given in lieu of the service which has already been granted.
That means there cannot be duplicate. Twice he cannot take.
Duplicate ಬೇಕಾಗಿಲ್ಲ ಅನ್ನೋ ಉದ್ದೇಶಕ್ಕೋಸ್ಕರನೇ the service, the benefit which was already granted in the 248 has to be
How that is treated by the tribunal?
Tribunal says that double benefit ಅನ್ಕೊಂಡು dismiss ಮಾಡಿದ್ದಾರೆ. I am seeking for double benefit ಅಂತ, it is not so.
ಡಬಲ್ ಆಗಲ್ಲ ಅಂತ.
Double ಆಗಲ್ಲ ಅಂತ ಹೇಳ್ತಿರೋದು ಅಷ್ಟೇ.
Requires consideration.
Please.
Issue.
Government advocate may be directed. 1 to 3.
Government,
Yes,
ಹೌದು
ma'am.
ಸ್ವಾಮಿ.
1 to 3.
ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡಿ.
ಕೊಡ್ತೀನಿ.
AG is requested to accept notice for respondents.
That may be called.
ಅದೇನ್ ಡಬಲ್ ಆಗ್ತದೆ.
ಅದೇ.
Yeah.
In lieu of that ಅಂತಂದಾಗ I have been given 1 year, my lord.
ಹಾ.
I am entitled for 2 years. 1 more year I am entitled ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ. It may be taken up in any January or February.
ಬರ
Maybe. May
Next.
please for that date.
ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡಿ. ಬರ
ಆಗ್ಲಿ sir.
ಎಸ್.
My lord, kindly pass over, my lord. We are arguing another board.
ಮಧ್ಯಾಹ್ನ ಇಟ್ಕೋಬೋದಾ?
ಆಗ್ಬೋದು, ಮಧ್ಯಾಹ್ನ ಎಲ್ಲ ಸುಮಾರು ಇದೆ, ಆಗ್ಬೋದು. ಸ್ವಲ್ಪ ನನಗೊಂದು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಮಾಡಿ
ಹಾ,
ಬರ್ತೀನಿ.
ನಿಮ್ಗೆ ಯಾವಾಗ ಆಗತ್ತೆ ಬನ್ನಿ, ಅವಾಗ ನಿಮ್ ನೋಡಿದ್ಮೇಲೆ ನಾವು ಕರೀತೀವಿ. Advocate General, Mr. Learned AG is also here, not in this matter.
Next.
All. Pass. ಅದರಲ್ಲಿ madam appearing for BDA, you have, we had made some order. You have prepared that one? Do you have that? That affidavit you have? Anyway, it's all come afterwards. Yes.
Your Lordship,
Isha.
directed to delay in taking initiating disciplinary action, my lord. And within what time will we complete the disciplinary action is 2 questions, Your Lordship, were pleased to post on the last date of. What is interesting is, my lords, around 2018, I had appeared in this arbitration. After some time, they said your services was not required. Here is the case, my lord. Work nearly, for extra item of work, nearly 900 crores is, it's actually virtually more than the main work itself, my lords. Pursuant to which, my lords, around 400 crores was awarded. Your Lordship, may kindly see page 1. This even though this matter pertains to suspension of these 28 employees, my lords, which has taken place, there has been considerable delay in spite of the report which was received in the year 2022, my lords. Now I have given the timetable, Your Lordship, I mean schedule, my lords, page 7. Page 7.
Question our memory.
The petitioners are the employees of my lord Public Works Department, deputed to my lord third respondent corporation. Lord, in respect of my lord certain works, Lord, during which has taken place in the year 2009 and 10, Lord, a vigilance wing submitted a report which states that my lord the work is executed in accordance with the specification. There is no fabrication of records, which was not submitted on 26/2011. Thereafter, my lord, the contractor, my lord, invoked the arbitration clause. An award was passed on 25/2/2016 for a certain amount. Against that, my lord, the state preferred an appeal. Lord, in the appeal, there was a argument that these petitioners have colluded with the contractor and produced certain fabricated documents and ensured that award is passed in their favor. Lord, appeal was dismissed.
On that contention, what
Thereafter, my lord, another report was submitted in the year 2017, which says that, my lord, there is absolutely no fabrication of record. It is the committee which is constituted by the, my lord, state government. There are 2 reports which says that, my lord, there are, my lord, one report.
yeah, that was 34.
Yes,
34.
yes.
Whether issue was framed on that.
Issue is not framed.
No.
Issue is not framed.
Not, in fact, we appointed Captain Raja Rao, my lords, former engineer in chief, on 14th March 2028. His report has been given, clearly shows manipulation and interpolation of documents, my lord.
But did you take up that contention before the court?
In the arbitration, my lords, in fact, that was taken, in fact, KNNL was not made a party in this, my lords, who the beneficiary.
Will come then.
Please,
Did you take up that contention?
in the
That,
arbitration.
in the arbitration?
My lord, in fact, my lord, at that point of time, we are not aware of that has been taken, but.
Where is that?
It is,
Where is that? Just show that.
Where is it? It's not the report is asking, just tell me.
Not page.
Now page. Where have you taken up that contention in your written statement? Another reply statement.
Reply to the arbitration.
Claim petition.
Claim
reply.
petition. So
Reply
those
then
rec-
LLD, ತೋರ್ಸಿ.
Those records are, this is only service matter, Manoj. We are not produced the arbitration.
Where have you taken up that contention under section 34?
I can place all that before your lordships, Manoj.
Where is that?
That is not produced, Manoj. Need to produce all those.
ಬೇಕಾಗ್ತದಲ್ಲ?
Manoj, we'll produce all that before your lordships, Manoj. But the only question is here, a short point.
ಅಲ್ಲಿ ನೀವು ತಗೊಂಡು treated and rejected. Other impact ಏನಾಗ್ತದೆ? ಎರಡು ನಮ್ನಿ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ನಿಮಗೆ.
Matters pending before your lordships, Manoj, in the sense in before MFA and before this court itself.
Before us only. Before some other coordinate bench.
MFA number 200.
ಅಲ್ಲಿ ಯಾವ contention ತೋರಿಸಿ ನೋಡೋಣ.
Just, I have not looked into.
Did you take up that contention in section 34 petition?
34, it has been
But
taken, my learned.
ಎಲ್ಲಿದೆ? ಎಲ್ಲಿದೆ?
But
Show it.
it is taken, my lord. Page 295 is the,
295 of the
in the writ petition.
writ petition.
Yes. Lord, I am conscious of the fact that, my lord, issue is not framed.
That's all right.
Issue is
If
not.
both, what Supreme Court says is, if both the parties have understood each other's case, which your friend was arguing other day,
Yes.
we accepted your contention. If both the parties have, about 2-3 years ago, if both the parties have understood each other's case, non-framing of issue pales into insignificance. This is how we have held that way.
Yes,
Yeah.
Mr.
Where is that? Where is the contention they have taken?
Page 295.
295. Just read.
295.
But your lordship is having, my lord, writ petition 24132.
134 I am having. We'll have 132 itself. No issue. It may not amount to res judicata is also true.
Page number,
Learned AG,
please, ma'am.
the
One-
finding of the court
Arbitration.
this way or that way may not amount to res judicata qua the petitioners.
Please, ma'am, the only.
Because it is between two contesting parties. They work in the department. Therefore, even when arguably, we are thinking aloud.
Please, may I understand. What your lordships are saying is if happens both ways, well, if it's
Ah.
taken and contained, not considered also, what is the effect of it is what your lordship mulling
yes.
about, where does it?
Correct. Page number?
Yes, 295, my lord.
Fine.
Lord, fifth line, when the executive engineer has already admitted the quantities of works executed by the defendant number 1, contractor in the first statement of the objections filed, Tribunal observed that there was no need for the defendant number 1 contractor to prove the quantities. Even then, endeavor was made by the arbitrator to determine, as rightly argued, mere suspicion of collusion that cannot be a ground to set aside the award unless it is established to the satisfaction of the court that fraud and misrepresentation in getting the award and also award passed is opposed to public policy to fit in ingredients of section 34(2) and it
ಈ ಫೈಂಡಿಂಗ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಎಲ್ಲಿದೆ ಮೊದಲು? Where is the argument?
arguments not but issue is at page 287. Then, my lord,
287.
yes, ma'am, there are only, my lord,
That issue does not figure.
Well, grounds for 34 is totally different, as your lordships are aware, my lords.
287 is the issue framed.
Anywhere yeah, in your WS, was it content, reply statement? Did you take up that contention? Where is that contention? Just show us.
In fact, I was not ready on that. I was ready only on the short point, what your lordship said, directed me to appear and make an affidavit. My apologies, my lord.
You want some other day?
Can I get back to you all?
Adnu ಕೊಡ್ಬೇಕು ನೀವು.
I'll
ನಿಮ್ಮ-
get back.
ನಿಮ್ಮ
to
reply
the-
statement.
I'll go through the whole arbitration proceedings and
Appeal memo. This
I'll-
one. And did you put that question to any of the witnesses?
in fact, if I remember correct, my lord, it is good 8 years back when the arbitrator said we will not lead any evidence, forget evidence, we'll go only by documents. He didn't permit to lead evidence in that matter at all. If I'm subject to correction, it was in 2017-18.
It happened that way.
There is no evidence. So I'm just
Not allowed to.
not allowed to lead evidence. He said that we'll go only by the document. I'll just re-verify, my lord, because it is good 6-7 years
Call
back.
this
You need
next week we can call this.
next week, my lord. No problem.
Or week after next, whichever you want.
The week after next, my lord, said it. I'll just prepare a short synopsis along with that. And then
Call.
any date may be.
The other date could.
Please. Fourth, can I request?
The
Fourth.
fourth of.
ಅಂದ್ರೆ ಒಂದೇ week ಆಗುತ್ತೆ.
Fourth ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಇದೆ matters.
No, next,
6,
fourth
7.
will be next week after 12th court.
Ah, 12th. 12th, all right?
Interim order may be extended.
Interim order to continue.
But only other aspect, I think the MFAs are pending in this matters, because insofar what your lordship may have to see, whether insofar as the initiation of disciplinary proceeding vis-a-vis these petitioners.
ನೋಡ,
In fact, ಒಂದೇ bench hear ಮಾಡ್ಬೇಕು. ನಮ್ bench hear ಮಾಡ್ಬೇಕು ಅಥವಾ other bench hear ಮಾಡ್ಬೇಕಿದ್ನ.
Allah, the problem will arise if your lordship, usually I'm understand, it goes to the seniors. 16-1? 2025 date given matter. If I have no objection, if your lordships are to hear both the matters. my lord.
We have no objection if the other bench hear.
No, your lordships are hearing this matter. Allah, 2025 ಕೊಟ್ಟಿದ್ದಾರೆ, ತಾವು hear ಮಾಡ್ತಿದ್ದೀರಾ? I mean.
ಯಾಕಂದ್ರೆ ಆ ಕಂಟೆನ್ಷನ್ ನೀವು ತಗೊಂಡಿರಿ ಅನ್ನೋದು ನಿಮ್ಮ ಯುವರ್ ಸ್ಟ್ಯಾಂಡ್. ಸಪೋಸ್ ಆ ಕಂಟೆನ್ಷನ್ ಬೇರೆ ಸಮಸ್ಯೆ ಇದೆ, ಯಾಕೆ ಗೊತ್ತಾ? ನಾವ್ ಇಲ್ಲಿ ಏನಾರ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ಅವ್ರು ಮಾಡಿದ್ರೆ ಇವ್ರು ಉಪಯೋಗಿಸೋ ಪಾಸಿಬಿಲಿಟಿ ಇದೆ, ಅಥವಾ ನೀವೇ ಅದನ್ನ ಇವ್ರ ಅಗೇನೆಸ್ಟ್ ಉಪಯೋಗಿಸೋ ಪಾಸಿಬಿಲಿಟಿ ಇದೆ.
Then we'll,
It is
just let me
better.
go through it on 12th, my lord.
Instead of that, what we'll say is, we leave it to the wisdom of Honorable Chief Justice.
ಅಲ್ಲ 12th
Let
ಮೇಲೆ
it
ನೋಡ್ಬಿಡಿ, 12th ಬರ್ಲಿ, ಆಮೇಲೆ ಬೇಕಾದ್ರೆ we can tag it, or I leave it to your lordship, whatever you.
ಈಗ ನಾವೇನಾದ್ರೂ ಇವ್ರ ಮೇಲೆ ಏನು ಇಲ್ಲ, ಪೊಲ್ಯೂಷನ್ ಇಲ್ಲ ಅಂತ ನಾವು ಬರೆದು ಬಿಟ್ರೆ ನಿಮ್ಮ ಅಪೀಲ್ ಕಿತ್ಕೊಂಡು ಹೋಗ್ತದೆ ಅಲ್ಲಿ.
ಗೊತ್ತಾಯ್ತು. Financial implication is huge.
500 odd crores ಇದೆ ಅದ್ರ.
Within
Yes, ma'am.
huge ಇದೆ.
ಮತ್ತೆ ಹಂಗಾಗಿ ಅದು ಬರ್ಕೊಳ್ರಿ. Learned Advocate General submits that
Yes, number good.
the arbitration matter is being argued in MFA number
200287 of 2018
200287 of 2018.
and connected matters, my lords. I'll give, yes. Bangalore and.
ಧಾರವಾಡ
been transferred to.
Transferred to after being transferred from Kalburgi bench to principal bench. And
Case
that-
numbers could be.
The coordinate bench has fixed
25th January, 16th January.
16/1/2025
Right.
as the next date of hearing. And therefore, it is desirable that one bench may take up both the matters, since they have propensity to cast their shadow or light or shadow on each other. Full stop. This we cannot do on our own. Full stop. Therefore, we direct the registry to place the matter at the hands of Honorable the Chief Justice for necessary orders.
Then can I request, can I give the other 2-3 other connected case numbers to the court officer? my lord?
ಕೊಟ್ಬಿಡಿ. ಅಲ್ಲಿ MFA ನಂಬರ್ ಇದೆಯಲ್ಲ, ಆ ಬೇರೆ ಬೇರೆ ಬರ್ಕೊಂಡ್ಬರೋ.
Well, my learned friend will.
ಇವರು ಎರಡು ಮುಗೀತದ. Yes.
Interim order to continue, my lord.
ಅಲ್ಲಿ entry moderate. Entry orders are like cash prize.
Interim relief.
Ah.
Lord,
Ah.
Lord, this is pertaining to my lord suspension. Lord, what I would say is, my lord, the in view of 10(5)(b), Lord, 6 months elapsed, my lord, the state has not issued the charge memo. Therefore, my lord, it is deemed to be order of suspension goes soon after, my lord, 6
Look
months.
into that and get.
23/9/2024. Therefore, my lord,
Issued,
without
my lord.
going into the, my lord,
ಹಂಗಾಗಿ ಇದಕ್ಕೇನ್ ಸಂಬಂಧ ಪಡೋದೇ ಅಲ್ಲ ಅದು.
no,
ಈಗ ಜಾಯಿನ್ ಮಾಡಿದ್ದು we were under the impression that already they were punished ಅಂತ.
no. Lord, we-
Suspension, my lord.
ಸಸ್ಪೆನ್ಷನ್
Suspension.
ಇದೆ. ಹಾಗಾಗಿ ಈ ಆರ್ಡರ್ ಬೇಕಾಗೋದಿಲ್ಲ. ನೀವು ಇಷ್ಟ ಹೇಳ್ಬೇಕು. After that period, how you are justified in continuing the suspension because of apex court judgment ಯಾವ್ದದು?
Ajay Kumar Chaudhary and, my lord,
ಚೌಧರಿ versus so and so, so and so.
I'll get back, then your lordship.
ಅವ್ರಿಗೆ ಕೊಡಿ.
I'll
ಇದನ್ನ
get-
recall that.
Because last time,
May not be necessary.
last order was
That-
to.
clubbing the matter may not be,
Huh?
my lord,
ಅದೇ ಅದಕ್ಕೆ ಅದನ್ನ ರಿಕಾಲ್ ಮಾಡಮ್ಮ ಆರ್ಡರ್. ಹಂಗಿದ್ರೆ ಬೇಕಾಗೋದಿಲ್ಲ.
Then your lordship.
my lord, the-
I mistook.
my lord,
No.
the issue is, my lord, 18/1/2024, we are placed under suspension.
Once the charge memo is not issued within 6 months, ಅಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 3 months
It was,
relating to central rules ಅನ್ನೋದು.
no, my lord, it is amended.
Amended.
Therefore,
There also
6
months.
I'll get, because last order of your lordship dated 19 November 2024 was regarding why the delay and within what time we'll complete. I was just
In
prepared
that direction.
in that light, my lord. If I'll just get, my apologies. my
One
lord.
sentence. Learned Advocate General, on our request, appearing before the court in the matter, has filed the affidavit of
Additional, additional chief secretary.
Additional Chief Secretary, Shri Gaurav
Gupta,
Gupta,
please.
Gupta, in terms of our order dated
19th November 2024.
19/11/2024. First, the same are taken on record. First. ಈಗ
This
Only-
I'll get back your lordship next, other short
next
point.
week,
Next week,
ಮಂಡೆ ಹಾಕೋಣ.
Monday ಇಲ್ಲ, Tuesday
Ah,
ಹಾಕೊಳ್ತೀನಿ.
Tuesday.
Third, ಮೂರನೇ ತಾರೀಕು,
ಅಲ್ಲ, 3ನೇ ತಾರೀಕು ಹಾಕ್ಬಿಡಿ.
please.
ಅಷ್ಟೇ ಕೇಸ್.
I understand.
ಮುಗಿದ್ಬಿಡು.
I'll just come
Okay.
back on.
ನಿಮ್ ಬೇರೆ ಏನೆಲ್ಲ ಮಾಡ್ಕೊಳ್ಳಿ.
ಗೊತ್ತಾಯ್ತು.
ಸಸ್ಪೆನ್ಷನ್ ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
And board out.
Because of apex court.
I board out.
again, I would request for continuing the interim order.
Entry order to continue. All right. A request again, rest judicata ಇಲ್ಲ ಏನು. Any number of times you can request. Yes.
Number 27, my lord, it is
27.
28 years old matter, my lord, every.
ಯಾರೋ ಟೈಮ್ ತಗೊಂಡು ಹೋದ್ರೆ ಇದ್ರಲ್ಲಿ
Then
ನೋಡಿ. ನೀ ಪೇನ್
28 years old, my lord, my client without any income for
Week of
last
next
28 years.
week after. ಬರ್ದಾಗಿದೆಯಾ? ಬರ್ದು.
Next
Otherwise
week,
you will- ನೀವು you should sense what the lawyer is going to do and you should be here to counter it.
Lord, at least we owe a duty to inform the other side also, my lord.
ಹೌದು.
They have
ಅಲ್ಲ.
intimate, then only they have to move before your lordship.
ಹೇಳೋದಿಲ್ಲ.
Either myself or myself. Lord, if it is
Therefore,
not
proxy
inconvenient, may I
counsel for
request
appellant,
next week, my lord,
Proxy
subject.
counsel appearing for appellant.
Ah.
We had informed, my lord, I took his number and I had messaged him. Before that, I couldn't do it, my lord.
He sent
I-
that message to told
All
around,
right. Not, ಆ date
Yeah.
ಹಾಕಿ ಬರ್ದಾಗಿದೆ. Next.
may make a date, my lord, actually my part.
ಸೈನ್ ಆಗಿದೆ.
Ah,
ಆರ್ಡರ್ ಸೈನ್ ಆಗಿದೆ. ಅಲ್ಲಿ ಇದು ಆರ್ಡರ್ ಬರ್ದಾಗಿದೆ.
oh,
ಸ್ಕ್ರಿಪ್ಟ್ ಆಗಿದೆ. Otherwise would have changed it.
please,
right
my
now.
lord, I'll,
Next.
week of next date one, ಅದರಲ್ಲಿ ಸೇರ್ಸಿ.
ಅಲ್ಲಿ ಅಲ್ಲ ಆರ್ಡರ್ ಇಸ್ ರಿಟರ್ನ್ ವಾಟ್ ಎವರ್ ಆರ್ಡರ್ ಇಸ್
My lord,
ರಿಟರ್ನ್.
what has happened, my lord, several times I suffered at the office, in spite of our lordship order and court officer.
ಅಲ್ಲಿ ಬರಲಿಲ್ಲ
instruction.
ಮೂವ್ ಮಾಡಿ. We remember.
ಯಾಕಂದ್ರೆ ಅವರು ಹೇಳಿದ್ರ ಗತಿಗೆ ಡೇಟ್ ಕೊಡ್ಲಿಲ್ಲ ನಾವು ಮಾಡುದಿಲ್ಲ ಅಂತ. Then I have to move it ಆರದು, I have to move before the court officer. Then court officer,
ಬೇಡ,
then next week means next a particular day he.
We remember every word you speak today. It is stored now.
My lord, I am,
Memo.
I am fully aware of it, my lord. I know that your lordship is very, very
Ah.
good memory that cannot be
Any-
doubted
small
at
thing.
all.
We'll
Yes,
do that. Okay.
but
Appearing for respondent, my lordship. Appearing for
Ah.
respondent, kindly pass over, my lordship.
Passover,
Yes, my lordship.
28, 2016 matter. Yes. All right.
I'm the
pass over.
proxy counsel, my lord. Respondent is on the way. is coming.
Kindly give some other date,
Some other date.
it will be better.
All right. Which date? Not
Nearest any date, my lord.
16th of December.
Thank you.
Much
Okay.
obliged. my lordship.
To enable council,
Thank you.
CGC to come and argue.
Much obliged.
Okay. Yes, Mr. Bhalla.
Petitioner, my lord.
Ah,
The petitioner, my lord.
others need not wait. Perhaps this matter will go on. Ah.
Petitioner, my lord, was this,
What?
the Geological Survey of India in Hyderabad, my lord.
Ah,
He is challenging the charge memo issued to him, wherein about 6 charges have been framed against him. My lord, the Hyderabad bench held that it has no jurisdiction and it may be filed with the appropriate bench, and thereafter behind the bench it has been filed, my lord. This way has been filed. That has been admitted, my lord, by this Bangalore bench, and as a result, by virtue of Section 19(4), all proceedings have been abated, my lord, because it was pending before this CAT. In the meantime,
abated because
the matter has been admitted by the CAT.
admitted by the CAT.
Without obtaining CAT's permission, my lord, the respondents proceeded with the disciplinary action and dismissed the applicant from service. I mean, the petition from service. The question is, I take your lordship to the relevant post annexure E, Lord, that is the section 19(4). I will take your lordship.
Of Administrative Tribunals Act,
Yes, ma'am.
19(4). What is act?
Kindly see page 23, my lord, annexure E.
Here, annexure E. 19, applications to tribunals,
Yes, my lord.
3, 4,
Four.
4.
For my
Where an application has been admitted by a tribunal under subsection 3.
Yes, my lord.
3 another. On receipt of the application of subsection, the tribunal shall, if satisfied after the inquiry, mediation is a fit case for adjudication or trial by admit such application, but the tribunal is not so satisfied, it may summarily reject. Every application shall be in such form and such.
Now I will take your
4,
lordship.
where an application has been admitted, every proceeding under the relevant service rules as to redressal of grievance in relation to the subject matter of such application pending immediately before such shall abate and say whether appeal or presentation is ordered. In departmental ಏನಾದ್ರು ಇದ್ರೆ they go ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ.
Yes, my lord. Now I
Subject
take
to
your,
outcome of the application.
I'll take your lordship to the relevant order of the tribunal at page 33, annexure H. Order dated 17/12/2015. A short order, my lord, I will just read that. We heard the matter during the hearing. We were confronted with the order number so and so dated 26/11/2015, which indicates that while this matter is admitted and pending as on 29/4/2015, an order seems to have been issued on 26/11/2015, which was following the applicant's joining report number nil dated 23/11/2015. We require some clarification from the respondent number 2, but as an initial action on it, we quashed the order dated 26/11/2015. Apparently, the learned counsel for the respondents is also unaware of the full details of it. Anyhow, we require some assistance from the second respondent. Let him be present on 6/1/2016 at 10:30 AM with the file, post on 6/1/2016. This is the order, my lord. Subsequent, my lord, another bench recalls this order at page 44, annexure K, recalling the order, my lord. The ME applicant submitted this application seeking to recall and set aside the order dated 17/12/2015, which I just read now. The OA is filed by the applicant seeking to set aside the annexure A1, the charge memo issued by the second respondent in the OA. This tribunal-wide order dated 29/4/2015 admitted the OA and issued notices to the respondents by Dusty. By way of interim relief, the applicant prayed for stay of all further disciplinary proceedings
and pass such interim direction to restrain the second respondent from taking further action in pursuance of the impugned order in Annexure A1. Though interim relief is sought for, this tribunal did not pass any interim order. Interim order restraining the second respondent from proceeding further. Since there was no order of stay or injunction or direction as the case may be, the second respondent continued with the disciplinary proceedings and final order of punishment was passed on 23/11/2015. Taking note of the final order dated 23/11/2015, this tribunal passed an order on 17/12/2015 whereby the punishment order dated 23/11/2015 was quashed. The present way.
They say it stands record because they had no opportunity, full opportunity. And secondly, you had not moved any application at all.
Yes, madam.
Only on their own they did it.
Yes,
So moto.
yes, madam.
This is how this we find again further straight away swine. So therefore they say we will hear it, him and then we'll pass orders ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Yes, madam. The question is, my lord.
Ah.
Final order was passed, my lord, as per annexure. M, page 53. I'll just operative portion, I'll read, my lord. At page 60.
53.
53, my lord, annexure M is order, final order of the tribunal.
Which you are challenging.
I am challenging this one because this order, my lord, yes, I am challenging this order only. Kindly see page, there are 11, my lord, page 60. During
the course of hearing.
It has been brought to our notice that the inquiry proceedings have already been completed and an order has been passed by the disciplinary authority imposing the penalty of removal from service by order dated 23/11/2015. The applicant submitted that since the matter is seized up by the tribunal, the parties.
What you say is, once application is admitted, because of subsection 4 of section 19, all other proceedings wherever they be would abate.
Yes, madam.
And therefore the 2015 order could not have been passed.
Yes, madam.
That's your contention.
Yes, madam.
What is meant by abate?
No, that becomes invalid.
How
Disciplinary
should
action
abate is interpreted by the apex court. It all depends upon in which section it. For example, apex court interpreted the word abate in repealing the Urban Land Sealing Act repeal was done. Section 3 of the Repeal Act said all proceedings would abate. There the Supreme Court interpreted what is meant by abate.
I might have used this word abate, but other proceedings becomes invalid rather. Because
That's not that simple. Abate means die,
Yes,
die away, wither away.
True, my lord.
English meaning is that way. But Supreme Court said the meaning of this word depends upon the context in which the word is employed. There is such a judgment. Which Urban Land Sealing Act was repealed, and I think it was repealed in 1991 or 93, I do not know. That was considered by the apex court in the light of that repealing act, or the word abate. Supreme Court on Words and Phrases by Surendra Malik.
no, anyway, effect of this para, your lord, I'll just read the para, my lord.
How courts have interpreted this provision? How various high courts in the country.
No, I could not get any reported.
No,
this, my
reported
lord.
judgment.
No.
Really.
Because statute says, my lord,
Abate, it means abates.
yes.
Abate means, my lord, the Supreme Court says, my lord, abate means
Wither away, vanish
temporary
away, die.
suspension or closure or die.
Correct.
Lord, Learned Senior Counsel,
it's
what is pointed out is true, my lord. The court, the department should have not proceeded and passed the order. That's the
Without
first point.
permission of the tribunal.
Without permission of, because 19(4), it's a bar, my lord, that it's shall, the word is used, admission shall abate. So therefore, my lord, the respondent should not have proceeded. That is my first point. My lord, as an officer of the court, my lord, I just point out, my lord, this one decision of Honorable Justice K. Chandru referring a judgment of the Honorable Apex Court in the last
Madras
date,
High Court.
Madras High Court. Lord, this is in fact, my lord, I pointed out this matter before his lordship when the matter had come up with a coordinate bench, Justice Dinesh Kumar. But this matter, my lord, there's no judgment on this point. On this point, the judgment said, my lord, sir, ಈ judgment ಇದೆ ಅದರಲ್ಲಿ Justice Chandru.
ಏನಂತಾರೆ ಓದಿ?
My lord, it says, my lord, now it is brought to the notice, para 4, my lord, para 4. The lordship got it, my lord?
There are four.
Para 4.
Yes.
It is now part of the notice of this court, but I'm sorry, his lordship did not get.
That subsequent to the
Sub-
filing of the original application,
Both the petitioner and the third respondent have retired from service with reference to the issue of section 19(4) of the Administrative Tribunal Act operates as
or
a-
against the state government from pursuing the said question is no longer a sine qua. Supreme Court held that section 19(4) of the admitted does not bar the government from passing appropriate orders.
Please,
Merely because an original application is pending before the tribunal, the government need not have stopped dealing with the review application. It is necessary.
please. No, my lord, senior is true in telling that. My
What
lord, that,
happened to?
that is the reason, my lord, that Supreme Court judgment is not on that point. Therefore, I just want to.
Therefore, I doubted it cannot be like that. That
Therefore-
would be virtually killing that very section,
Please.
subsection 4
For
itself.
itself, my lord. Therefore, my lord, I just wanted to bring it to your lordship's notice, sir. Sir, that was the only judgment, my lord, we found. On this point, my lord,
The Deepak Mali was not on that point at all.
no. It's there, my lord. It's there in the file, my lord.
Asian. Only Koila service on account of the pendency. The experience, 99% of the persons are unable to review the respondents. Idu Malina?
Not, sir. This is the judgment Justice Chandru referred to, but
It does not refer to that at all.
that does not say so, my
This
lord.
we have referred in some judgments actually. This was on the longevity of suspension period.
Therefore, my lord, on this point, my lord,
No judgment.
no judgment, my lord. I'm at your lordship's hand, my lord. If your lordship lay down this, my lord, if once the matter is admitted, my lord, irrespective of the stake,
How word abate is interpreted by the apex court?
Lord, the apex court says, my lord, is that, my lord, the temporary suspension or closure of legal proceedings, abatement can occur on number of reasons, my lord. That is the interpretation of the abatement, my lord, by the.
In which judgment it said that? Was it in relation to repeal of Urban Land Ceiling Act?
No, my lord, not on that, my lord.
The judgment. Shanti Bhushan.
Please, my lord, please,
Judgment is not come.
please, my lord.
Apex court interpreted the word abate appearing in section 3 of repealing act.
Please, I'll look into it.
Was it there?
Please.
Ramnath Iyer also has given in his law lexicon, the latest 17th, 18th edition. He has given the meaning of abate. I have treated that word abate in criminal proceedings. On the death of accused, the criminal proceedings abate on one section in the CRPCL.
Please.
In the light of that, I treated it about 4 years ago. I have discussed what is meant by abate in that. Generally, what is meant by abate, how concept of abate operates in English law, Indian law. That way I have structured that judgment. Just look into it and come back.
Please.
Abatement. This is the Pandit Madan Swaroop. So, Public Charitable Trust. This is at AR 2000 SC 3415. My own judgment is. I have referred to this judgment also. I remember. Correct. Section 4 of Urban Land Ceiling Act. This 2010. Just look into. Next week, Hakola?
Please.
Next week, Hakola. Assist Madbek.
Please.
Because there is no such judgment except this Justice, Honorable Justice Chandru's judgment.
Justice Chandra's judgment, my lord, referring the Supreme Court.
Sometimes it happens.
Yes, sir.
With reference to that Supreme Court judgment independently.
ಅದು ಮಾಡ್ಬೇಕಾಯ್ತು ಹಂಗೆ ಹೇಳಿದ್ರೆ ಸುಮ್ಮನಿದ್ವಿ ನಾವು ಈಗ ಅಲ್ಲಿ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನು
No, my lord, I brought it to Justice.
it appears what Mr. Holla is saying. Holla is an encyclopedia of service law.
No, my lord. That's too, my lord.
an opportunity to talk to him and learn many things.
How is his health? Is he all right?
He's too old, he's not going out. He's inside.
The last matter he argued was that Mulagini matter, which I had argued before in our court, very ably. Yes. Muli. Yes. Not company.
Please.
Criminal just it's not dikshit on abatement of proceedings or what judgment. See, when you come just hangay ad sanction helodu ododu ಮಾಡಿದ್ರೆ relief ಕೊಡೋದೇ ಇಲ್ಲ ನಾನು. The bar should be improved. Bar pressure agdagle improve ಮಾಡ್ತಾರೆ. On their own they will never do. Subject to many few exceptions like you. Therefore, especially youngsters ಬಂದ್ರು ಅಂದ್ರೆ I keep them on their toes. ಅವ್ರು ಏನಾರ ಹೇಳಿದ್ರೆ ಕೇಳೋದಿಲ್ಲ ನಾವು. ಅದ್ರ ಮೇಲೆ ರಿಸರ್ಚ್ ಮಾಡ್ಕೊಂಡು ಅದು ಹೆಂಗಿದೆ ಏನೆಲ್ಲ ನೋಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು. ಅದು ವೇಸ್ಟ್ ಆಫ್ ಟೈಮ್ ಅನಿಸ್ತದೆ. ಒಂದೊಂದ್ಸಾರಿ ಇರಿಟೇಷನ್ ಆಗ್ತದೆ ನಿಮ್ಗೆ. ಏನಪ್ಪ ಇಷ್ಟು ಸಣ್ಣ ಮ್ಯಾಟ್ರು ಇದಕ್ಕೆಲ್ಲ ಯಾಕೆ ದುಡಿಸ್ತಾರೆ ನನ್ನ ಇಷ್ಟು ಅಂತ. After 10 years they will know. Otherwise they will be like cattle trespass lawyers. We don't want such lawyers. We want constitutional lawyers. Yes.
Great.
Yes. Mr. ASG, what is
Item 31.
31?
But this is regarding that intelligence bureau.
Where he went, he was not
Yes.
provided vehicle, etc.
His grievance was vehicle was not provided. Would your lordship take it up in the afternoon or neither day?
Afternoon, ಬೇರೆ ಏನಿದೆ? ಎಷ್ಟಿದೆ? Afternoon, we'll take that matter also, unless you have some
yes.
difficulty.
Before Justice Hemant, there is a constitutional validity challenge to section 132 of the Companies Act, part third matter.
I see. All right, we will have this matter week after next.
Yes.
Okay. ಏನೋ some material ಏನೋ produce ಮಾಡ್ತೀವಿ.
Yes, Pramod has already filed. It is ready.
Copy serve ಮಾಡಿದಾರ? Copy ಕೊಡಿ.
We'll serve a copy and then file it.
Advance ಕೊಟ್ರೆ.
ಹೌದು.
Come with, otherwise ಮತ್ತೊಂದು date.
ಹೌದು. I understand.
May I request for a date, Manoj?
Huh?
I request for a date.
It 2 weeks ಆದ್ಮೇಲೆ ಮೆನ್ಷನ್ ಬರುತ್ತೆ. ಬರಲಿದ್ರೆ ನೀವು ಹೇಳಿ, we'll fix, we'll get the memo. ಅಲ್ಲಿ ರಿಸ್ಟ್ರಿಕ್ಷನ್ ಮಾಡಿವಿ ನಂಬರ್ ಇಷ್ಟಕ್ಕಿಂತ ಜಾಸ್ತಿ ಹಾಕ್ಬಾರ್ದು ಅಂತ. ನಾವು ಡೇಟ್ ಕೊಟ್ಟಾಗನೇ ಒಂದೊಂದ್ಸಾರಿ ಎಕ್ಸೀಡ್ ಆಗಿಬಿಡ್ತದೆ.
Can we take a date from Raghavendra? If we take it later, he can verify. And
Perhaps for his schedule, Manoj.
Correct.
That is
You need
also schedule.
ಒಂದು ಯಾವ್ದು 16-12.
Very well.
All right?
Very well.
Okay.
ರಾಘವೇಂದ್ರ ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ರಲ್ಲ ಯಾವ್ದು ಸಾಹೇಬ್ರು ತೋರ್ಸಲ್ಲ ಸ್ಲಿಪ್ ಅಲ್ಲಿ ಕೊಟ್ಬಿಟ್ರ ಶಾಂತಿಗ
Serial number 5, sir. Sir. Serial number 7.
ನಮ್ದು ಒಂದು 35 ಇದೆ ಮಧ್ಯಾಹ್ನಕ್ಕೆ. ನಮ್ದು ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ತೀರಾ? ನಮ್ದು ಮಧ್ಯಾಹ್ನ ತಗೋತೀರಾ?
40 last number.
40 ಯಾವ್ದು urgent?
40 ನಮ್ದೆ. ಸರ್ 39 ಆಗಿದೆಯಾ? 39.
ಯಾವ್ದು
ಕೊಡಿ ಕೊಡಿ. ಮಧ್ಯಾಹ್ನ
ಮೇಡಮ್ ಎಷ್ಟೊಂದು ರೀಚ್ ಆಯ್ತು?
Thank you. Pass or rest. Pass or rest. Thank you. ಹೇಳಿದ್ದೆ. ನಿಮ್ ಪಾಸ್ ಅವರ್ ಸರ್.
That is the answer of this radio. Since he is I want to take that back. That's why I approach you. Why did you not done? I do not know. Get that info now. Have changed that procedure now. Exterior officer who does not have any experience in the police cadre. Yes, yes. He can't write up. Who has experience on the initiative? There is also been with DD whenever the IPS is made. So in that line, he is right in asking. Now they have agreed. So that we will place it on record. Exactly. As a reply to this, your reply is as well as we will place it on record. Oh, no. ನೀವು ಎಲ್ಲ ಆಯ್ತು ಮಾರ್ಚಿಂದ ಮಾರ್ಚ್ ಎಲ್ಲ ಬಿಟ್ಟು ಸಾಕು 1.5 ವರ್ಷ ಬೇಕು. ಆರಾಮ ನಿಮ್ದಾಯ್ತು ಈಗ ಮೊನ್ನೆ ಯಾರೋ ಈಗ ಮೊನ್ನೆ ಬ್ಯಾಚ್ ಬಂದ್ರಲ್ಲ ಯಾರು ಹಾಕೊಂಡಿದ್ದಾರೆ ದೇಶ ಇರ್ಲಿಲ್ಲ ರಾಘವೇಂದ್ರ ಗಾಯ सर वापस आते हो उनके साथ 851 of 2024 criminal petition वसूला जो करके 851 की 815 सर वो फाइल भेजोगे सर हाँ 815 of 24 criminal petition वो हाई कोर्ट बुक में लिखा नंबर लिखा हुआ है somewhere 160 or 170
Very informal.
Court officer, sir. Court officer, sir.
Wow.
we had a recruitment committee meeting.
Matters pertaining to Dharwad bench,
Ah.
pronouncement of judgment.
Firstly, we have taken more time, so you have to pardon me because I authored this judgment with the full help and cooperation of my brother. There is some delay, but it's a very long judgment. We have referred to many judgments. Yes. Appeals filed by the KIDB SLAO having been partly allowed, impugned judgment and awards of the reference court are downwardly modified, redetermining the market value of the subject lands by adding 30% of the sum specified in the SLAO awards in question. The enhanced compensation shall be accordingly computed by taking into account all statutory admissibles and be paid to the concerned landowner herewith. The amount deposited by the appellant KIDB or the respondent allotee, if any, shall be remitted to the reference court for satisfying the modified awards as now made by us, and the remainder, if any, including the amount already deposited in the reference court, shall be refunded to the concerned before long after ascertaining credentials. As a consequence of the above, the appeals filed by the land losers seeking enhancement of compensation, laying challenge to the judgment and awards made by the reference court are hereby dismissed.
Numbers ಅವ್ರು ಹಾಕಿಲ್ಲ. Appeal filed by KDB ಅವರು filed by land users ಅವರು. ಧಾರವಾಡ ಮಾಡಕ್ಕೆ ಕೊಯ್ದಾದ್ರೆ ಇರ್ತದೆ. ಮಾಡಕ್ಕೆ followed. Appeals of KDB partly allowed. Appeals of land users claiming compensation dismissed. ನೋಡಿ ಇದು ಫಸ್ಟ್ ಒನ್ 10079 partly allowed ಇದು ಅಪ್ಲೆಂಟ್
ಅದೆಲ್ಲ ಡಿಸ್ಮಿಸ್ ಕೆಡಿಬಿ ಎಲ್ಲಿರುತ್ತೆ ಅಲ್ಲಿ ಪಾರ್ಟಿ
ನೋಡ್ಕೊಂಡು ಇದು 1009 10097 SLAO ಎಲ್ಲೆಲ್ಲಿದೆ KDB ಅವ್ರು ನಿಮ್ಮ ಇದ್ರಲ್ಲಿ ಮಾಡ್ಕೊಂಡು
ಇದು ಸ್ವಲ್ಪ ಲೇಟ್ ಆಗುತ್ತೆ
ಕೊಡ್ತಾರೆ.
ಅದೇ ಕೆಡಿಬಿ ಅಪೀಲ್
ಮಾಡ್ತೀರಾ ಕನೆಕ್ಟ್ ಆಗಿದೆಯಲ್ಲ ಮಾಡ್ಬೋದಾದ್ರೆ ಅಂತ ಮೇಡಮ್ ಇದು ಪಾಸ್ಪೋರ್ಟ್ ಮ್ಯಾಟ್ರಸ್ 7 office subjections complied with leave of working pay office.
Lords, kindly,
Ah.
serial number 24, my apologies. my lord.
24.
24, pass
ಅದು ಇವ್ರದ್ದು
ಉದಯ ಹೊರಡ್ರು
ಹಾ.
affidavit ಹಾಕ್ಬೇಕಿತ್ತು.
ಹಾ.
ಒಂದು affidavit with regard to one resolution which they had referred, we have found out all the details. In that it is not found that affidavit is ready. But however, my lord, in respect of another resolution, what they are trying to refer, not those records are yet to be traced by us because they are not
So
available.
you want time?
We want some more
When
time.
do you want?
Lordship may grant me by Tuesday, next
1
Tuesday.
week ಕೊಡು ಎಂತ?
Please,
1 week.
please,
Hmm?
please,
ನೋಡಿ, ಯಾವ್ದಾದ್ರು ಒಂದು ಯಾವ ಡೇಟ್ ಕೊಡ್ತೀವಿ?
4th of December. Oblige,
4th of December ಅಲ್ರಿ?
please, my apologies.
ಅದು ಹೊಳ್ಳವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ.
ಹೇಳಿದ್ದೀನಿ, ಬೆಳಿಗ್ಗೆ ಅವಲೇ ಹೇಳಿ. Oblige.
ಇದಾರಲ್ಲ. Next.
First door matter, C number 7, Suresh.
Except translation, all objections have been.
Counsel for the petitioner submits compliance. First of registering to win. Okay.
First door matter, C number 12. You Anil Kumar.
It's for the petitioner, my lords. My lords, with regard to the form of the caste certificate, it is issued under Rule 3A of the 1992 rules.
1994 rules as amended in 2000.
1992 rules, my lords, as amended in 2000, my lords. Form D, my lords.
D.
Yes, my lords.
ಇದೇನ್ ಕಾಪಿ?
Yes, my lords.
ಅದು ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ ಇದೆಯಾ ಕನ್ನಡದಲ್ಲಿ ಇದೆಯಾ?
English ಅಲ್ಲಿ ಇದೆ, my lords. ಕನ್ನಡದ್ದು I have the rules. ಕನ್ನಡದ ಕಾಪಿನೂ ಇದೆ. I'll just pass it on, my lords.
ನಿಮ್ಗೆ ಇಶ್ಯೂ ಮಾಡಿದ ಕನ್ನಡದಲ್ಲ ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ?
ಎರಡರಲ್ಲೂ ಇದೆ.
ಎರಡರಲ್ಲಿ ಕೊಡಿ.
ಎರಡರಲ್ಲೂ ಕೊಟ್ಟಿದ್ದಾರೆ. 2017 ನಲ್ಲಿ, 2022 ಅಲ್ಲಿ.
Okay. ಅದು ಒಂದೇ ಗ್ರೌಂಡ್ ಮೇಲೆ ಡಿನೈ ಮಾಡಿದ್ರಾ?
Certainly.
That's the only ground.
Yes, my lords.
Tell it.
The objection that I've given, the representation is rejected. That is at page 119, my lords. Page 117. Annexure A12 is the final select list. ಅದ್ರಲ್ಲೇನೆ ನನ್ನ ಹೆಸರನ್ನು ತೋರಿಸಿ ಯಾಕೆ ಸೆಲೆಕ್ಟ್ ಆಗಿಲ್ಲ ಅನ್ನೋದನ್ನು ಕೊಟ್ಟಿದ್ದಾರೆ. That is found at page 128, 129. It is part of Annexure A12. Page 128 ಅಲ್ಲಿ serial number 12, Janki Rathod. She is the petitioner. The first paragraph, if I may read, my lords.
Janaki Rathod
Yes, my
is a
lords.
member of scheduled caste.
Yes, my lords. The caste certificate is found at Annexure A4 and A9, Kannada and
What is the ಆಕ್ಷೇಪಣೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಅಭ್ಯರ್ಥಿಯು
my lord, Akshepane is in the second column.
Ah.
She writes saying that with reference to the above subject, I Janki Rathod so and so requesting you to that I am filing objection to 1:1 forest watcher provisional select list which is published by so and so, so and so. Then 96.48 nan tagondidruno I have not been considered.
96.48.
Yes, my lords. The qualification is merely based on SSLC marks. In the SSLC, I have secured 96.48.
In SSLC,
Yes, my lords.
you did not study further thereafter.
My lords, I am told she has not.
ನೋಡಿ ಹಿಂಗಾಗತ್ತೆ. ಬೆಸ್ಟ್ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಎಲ್ಲ ಇಂಥ ವಾಚರ್ ಗೀಚರ್ ಕುತ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ. ಏನು ಉಪಯೋಗ ಇಲ್ದವು ಎಲ್ಲ ಚಲೋ ಪೊಸಿಷನ್ ಕುತ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ. ಪ್ರಾಬ್ಲಮ್ ಇದು. Such an excellent candidate. Yes, I will impose cost in this matter. She is a member of scheduled caste, 96 plus in SSLC. And you have treated that candidate this way.
Lord, initially she has produced Kannada.
Huh.
And subsequently.
Whatever has been issued,
Lord,
she has produced.
Notification what it says, my lord, ಅಭ್ಯರ್ಥಿ ಎಲ್ಲಾ ಸಂದರ್ಭದಲ್ಲಿಯೂ ಒಂದೇ ತರಹದ ದಾಖಲಾತಿಗಳನ್ನು ಸಲ್ಲಿಸತಕ್ಕದ್ದು ಈ
That is not
that is the
Westminster Abbey enactment. It's only some notification. And they are issued under the act. It is not that yado fraud madi matti. I can understand. 96 scheduled caste, 96 plus. What else you require?
Lord's judgment are also there, Ram Kumar judgment and
Ram Kumar we have treated na in
Yes.
that.
Devraju writ appeal.
Devraj.
We
Writ appeal 708 of 2022.
Body copy.
It is, I've already
They have
produced that.
annexed it.
I've actually annexed it before the tribunal itself, my lords, page 148 ಅಲ್ಲಿ ಇದೆ.
We'll impose cost. Anything you want to say about cost?
Cost, my lord. They have to follow the notification.
Well, let them, what is that? Follow the notification ಅಂದ್ರೆ ಏನ್ ಅರ್ಥ? 1 pound of flesh, not even a drop of blood, ಅದಾ ಏನು?
Lordships kindly direct to consider.
My lords, I must also indicate 4 post ಇತ್ತು, 4 post select ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. I have made them as party respondents, my lords. They are not before my lords because notice is yet to be issued.
Service has not been issued.
No.
No notice issued.
Not yet.
Then notice has to be issued. Otherwise you may not get the post
Yes,
at all.
I'll take hand summons, my lords.
Issue emergent notice. What kind of bad treat, what a bad government it is. Learned AG is requested to accept, on request accepts notice for 1 to 3, emergent notice to 4 and 5. Post immediately after
My lords,
service.
in
Addition to
addition,
taking usual steps, it is open to the petitioner to take a hand summons to the private respondents.
last week before the vacation, my lords, I'll serve and I'll get a copy, my lords.
Notice ಹಾಕಿ ಬರ್ಬೇಕು. Notice ತಂದು.
Yes, my lords. I'll move the matter after it.
ಅಲ್ಲ. Notice ಹಾಕು. ನೋಡಿ, ಅಷ್ಟ ಮಾಡಲ್ಲ ಅವ್ರು. ಅಲ್ಲ ಮಾಡಲ್ಲ. 96% ಇರುವಂತ SC/ST candidates ಅನ್ನ ರಿಜೆಕ್ಟ್ ಮಾಡ್ತೀರಿ
My
ಅಂದ್ರೆ
lord, notification.
God will not, ಕ್ಷಮಿಸಲ್ಲ ನಿಮ್ನ.
My lord, they have both the certificates. What made them?
You should have called. ನೋಡಮ್ಮ, ನೀನು ಕನ್ನಡ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ, ಇಲ್ಲ ಇಂಗ್ಲಿಷ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ, ಇಲ್ಲ ಕನ್ನಡ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ನೀವು ಮೊದ್ಲು ಯಾವ್ದು ಮಾಡಿದ್ದೆ
That
ಅದನ್ನೇ
relaxation
ಇಸ್ಕೊಂಡು
should be made in the notification.
ಅದು ಬಹಳ 45% ಅವ್ನು ಮ್ಯಾಲಿದ್ರೆ ಈ ಪ್ರಾಬ್ಲಮ್ ಆಗತ್ತೆ. ಇವ್ರಿಗೆಲ್ಲ ಸಫರಿಂಗ್ ಆಗತ್ತೆ. ಅದಕ್ಕೆ ಅವ್ರು ಬರೆಯೋದು ಮಚ್ ಆಡೋ ಸಿಗ್ನಿಫೈಯಿಂಗ್ ನಥಿಂಗ್ ಇದೆ ಅಲ್ಲ. ನಾವು ಹಂಗ್ ಮಾಡೇವಿ, ರಿಸರ್ವ್ ಕ್ಯಾಂಡಿಡೇಟ್ಗೆ ಹಿಂಗ್ ಮಾಡಿದೇವಿ, ಹಿಂಗ್ ಮಾಡಿರ್ತೀರಿ ನೀವು. ಎಸ್,
Much obliged.
ಏನಿದೆ?
A short accommodation in this matter for this reason.
ಅದೇ, you need not say reason. When you ask, we'll give you, we know what you are. ಅಲ್ಲ, 2 weeks? 2 weeks. At the request.
My only request that
Ah.
some date may be.
Some date ಬರುತ್ತೆ, please, ಬರುತ್ತೆ. Next. He will never ask time at all.
No,
Yeah,
I bow down.
Ah.
Here for the petitioner.
Short matter, long matter ಇದು.
It is seniority, ಸ್ವಲ್ಪ long matters.
Long matter, some other day we'll take that. After vacation, we'll take that. Follow.
Before vacation on Monday.
Before it's all difficult ಇದೆ, because we are held up in writing some reserved judgments. ಅದಕ್ಕೆ.
ಆಯ್ತು.
Immediately after vacation. Christmas vacation. Okay. Next.
In this case, my lord, it is connected with one more writ petition.
Call this
That-
matter along
that-
WP.
Already order is there, my lord, today is not listed. Connected matter ನಲ್ಲಿ
Second
order
week of January. Yes.
ಇದ್ರಲ್ಲಿ ಸ್ವಲ್ಪ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಸ್ವಾಮಿ, ಯಾಕೆಂದ್ರೆ
ಹಾ.
ದೇ ಆರ್ ಮೆಲೋಡ್ ದಿ ಡೈರೆಕ್ಟ್ ಕುಟೀಸ್ ಆರ್ ಮೆಲೋಡ್ ಕ್ಲೇಮಿಂಗ್ ಪ್ರಮೋಷನ್ ಅಬೋವ್ ಅಸ್.
Then the
ಸ್ವಲ್ಪ ಅರ್ಜೆನ್ಸಿ ಇದೆ
second week of December.
ಪ್ಲೀಸ್.
Okay. Second ಆಗಲ್ಲ, third week of December. Second, we have already calendar is full. Yes. Next.
34 ನೀವು ಮಾಡು.
Therefore, the petitioner.
My lord, the APSC called for, my lord, selection of 2 posts, several
It
posts.
requires consideration, ಸ್ವಲ್ಪ deeper consideration ಬೇಕಾಗುತ್ತೆ.
Lord, ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ, my lord, I worked for, my lord, 1.5 years. I was selected. 2 other persons, my lord, my lord, they were called for interview, but unfortunately, my lord, they were not eligible for that post. I was the only candidate, I was selected. My lord, I worked there. My marks were disclosed. My lord, rule says till the interview, my lord, marks should not be disclosed. My marks were disclosed. Thereafter, my lord, my appointment was set aside. The tribunal, my lord, directed the KPSC to redo the interview, my lord, after calling the respondent also. My lord, in fresh interview, my lord, I filed an application for stay also. My lord, the interview was done, and my lord, now she is selected. my lord, the total marks. Now, my lord, her marks is lesser than my marks in the first interview. I am put to prejudice because, my lord, my marks are disclosed this time. This is the
Entry
situation.
ಮಾಡಿರ್ತಾ ಕೆಳಗೆ?
Sorry, my lord.
Entry ಮಾಡಿರ್ತಾ?
My lord,
No entry.
entry model, my lord, it is subject to the result anta ಮಾಡಿದ್ರು. My lord, now, my lord, last occasion, my lord, when I argued the matter,
No,
this honorable
second,
court directed
second.
them, my lord, to verify whether there are any vacant posts after hearing the matter. My lord, there are
Post
vacant
ಇದಾವ?
posts
ಇದಾವ?
and I have also filed a memo, my lord, along with their RTI.
ಅವ್ರಿಗೆ ಕೇಳು.
I will verify.
ಇದೆ.
Last time.
4 post ಇದೆ. Now I have filed the memo also.
The AGA to state as to whether any vacancies do exist in the posts in question, please. Call this matter in the third week of December. Registry to share a copy of this order with the learned AGA for compliance. Okay.
Please.
Shivram.
Regarding unauthorized absence, my lord, dismissal from service, my lord, in 2000.
Yes, the substance, sir.
My lord, of course, my lord, there is 21 months, my lord. The reason being, my lord, the wife has filed several cases against the petitioner, my lord. And he was arrested, and thereafterwards criminal proceedings was initiated and various provisions of law, my lord, which are available to the women, your lordship. And in all the cases, he got acquitted, your lordship. In the meantime, he suffered illness, my lord, and a back operation was made, my lord. He was advised to go for bed rest. After the suspension order was revoked, your lordship, he reported to the duty. In the meantime, crime came to be registered against him, my lord, under section 498A and all those provisions of law. I have produced all the material, lordship. In all the cases, my lord, he was acquitted. Under this pressure, my lord, he was arrested and kept in jail, and then he was under that mental pressure, your lordship. Except that, my lord, there are no other allegations, my lord, in the past.
Service.
My lord,
Service ಎಷ್ಟು ವರ್ಷ ಆಗಿತ್ತು?
he was, my lord, of course, now aged about 54 years now, my lord.
ಎಷ್ಟು ವರ್ಷ ಸರ್ವಿಸ್ ಆಗಿತ್ತು?
A service ಅವ್ರಿಗೆ nearly about 22 years, my lord, service was there.
22 years service.
Yes, yes.
ಡಿಸಿಪ್ಲಿನ್ ಎನ್ಕ್ವೈರಿ ಏನಾರ ಆಗಿತ್ತಾ?
ಆ ಡಿಸಿಪ್ಲಿನರಿ ಎನ್ಕ್ವೈರಿ ಮಾಡಿ ಈಗ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ ಗೌರ್ಮೆಂಟ್.
ಇದಕ್ಕಿಂತ ಮೊದಲಿಗೆ
ಹಿಂದೆ ಯಾವುದನ್ನು there is no fast conduct. That's what I am saying. These are the facts, my lord, which brought him.
ಆ ವೇಕೆನ್ಸಿಗೆ ಬೇರೆ ಯಾರನ್ನಾರ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರಿ ಈಗ?
I'll have to take instructions on that.
ಇದುವರೆಗೆ ಯಾರನ್ನು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿಲ್ಲ ಸರ್.
But
ಇವತ್ತು
yes,
even
that-
today there is a dearth of appointment of surveyor, your lordship. Paper ಇವತ್ತು ಬಂದಿದೆ 700 surveyor ನ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಬೇಕು. There is a
Because that
shortage
is-
of surveyor. And ಇಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಅಲ್ಲೇ several writ petitions we have filed, your lordship,
ನೋಡೋಣ.
directing them to ದುರಸ್ತಿ ವರ್ಕ್ ಮಾಡೋಕೆ ಜನ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
ಅಲ್ಲಿ ಕೇಳ್ಕೊಂಡು ಹೇಳಿ ಇಂಥವ್ರಿಗೆ ಏನು
Unauthorized absence.
Correct.
Because of that.
He has given reason.
ಮೆಡಿಕಲ್
ಎಲ್ಲೋ ಹಂಗೆ ಮಜಾ ಮಾಡ್ಲಿಕ್ಕೆ ಹೋಗ್ಯಾನೆ. I can understand.
I'll ascertain, my lord, by.
ಅದನ್ನ ಸರ್ಟನ್ ಮಾಡಿ ಕೇಳಿ.
Please.
He is saying there will the estranged couple ಅವರು
Yeah.
ಅಲ್ಲಿ ಏನೇನೋ ಕೇಸ್ ಆಗಿರ್ತಾವ, 10 ಕೇಸ್ ಆಗಿರ್ತಾವ, ಹೆಂಟ್ ಹಾಕ್ತಂತಾವ್, ಗಂಡ ಹಾಕ್ತಂತಾವ್. he says that I suffered at the hands of the fate.
I'll seek instructions.
Everything on record.
Regarding vacancy.
ತಿಳ್ಕೊಂಡು ಹೇಳ್ಬೇಕು.
Yes, ma'am.
On this matter in the third week of December. The AGA to make a statement as to whether statement about the service records
Yes.
of the petitioner.
Yes.
Okay. ತೋರ್ಸಕ್ಕ ಆ ರೀತಿ ಹಂಗೆ ಕಿತ್ತ ಹಾಕ್ಬಿಡೋದು ಅದೆಲ್ಲ ಸ್ವಲ್ಪ ಏನೇನೋ ಡಿಫಿಕಲ್ಟಿ ಇರ್ತದೆ. ಓಕೆ. ವಿಜಯ್ ಕುಮಾರ್.
My lord, friend wants some time in this matter, Lord.
You want time in this matter?
Lord, I have some urgency, Lord, because the pendency of the present petition was my promotions stalled. Lord, my learned friend on the last occasion, he requested for file. I have provided the file, Lord.
ನೋಡಿ ಡಿಸೆಂಬರ್ ಥರ್ಡ್ ವೀಕ್ ಒಂದು ಡೇಟ್ ಕೊಡಿ. ಡೇಟ್ ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಇನ್ ದಿ ಥರ್ಡ್ ವೀಕ್ ಆಫ್ ಡಿಸೆಂಬರ್. ಇವೆಲ್ಲ ಒಂದು ಡೇಟ್ಗೆ ಹಾಕೊಂಬಿಡಿ, ಮುಗಿಸ್ಬೋಣ.
Grateful.
At the request of AGA. Bharat, next.
For the petition.
ಏನು?
That's recruitment to 2016 recruitment of motor vehicles. That's what has happened is I'm seeking for a relief of my lord's re-medical examination, which tribunal has denied. in par with my lord's coordinate decision, which is confirmed in Supreme Court.
huh?
My lords, what happens, my lords, wide annexure A5, in pursuance to selection process.
Same, ಇದು ಬ್ರೇಕ್
Motor vehicle inspector.
ಗವರ್ಮೆಂಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆಗಲ್ಲ ಇದು.
ಇಲ್ಲ ಸ್ವಾಮಿ, there, the medical test was conducted by the KPSC. The lordships held that no, once you have conducted rightly or wrongly,
Then you have to abide by.
ಅಂತ ಹೇಳಿ. Here, he has requested the tribunal to direct the KPSC conduct the remedical test. There is no provision for
Lords
that.
may kindly come to A5. Endorsement ಗೆ medical test first ಮಾಡಿದ್ದಕ್ಕೆ variance ಇದೆ. Endorsement ಹೇಳ, I'll show it, my lords, I'll show it.
ಅಲ್ಲ ಒಂದು ಮೆಡಿಕಲ್ ಟೆಸ್ಟ್ ಬೇರೆ
Medical test ಅಲ್ಲಿ ಇದೆ, endorsement ಅಲ್ಲಿ ಹೇಳಲ್ಲ. My lords may kindly come to page 75. Page 75, my lords. Annexure A5. Lords, it is,
ಯಾವ
One-
ಟೆಸ್ಟ್?
one six-
ನಾಕ್ನಿ ಟೆಸ್ಟ್ ಯಾವುದು ಯಾವ ಟೆಸ್ಟ್?
ಅಲ್ಲಲ್ಲ, height ಮತ್ತೆ chest endorsement.
ಹೈಟ್
Height and
ಅಷ್ಟು
chest.
ಬೆಳೆದು ಬಿಟ್ಟಿಯೇನೆ ಈಗ ಇಮಿಡಿಯೇಟ್ಲಿ
No, there it is given 169 and chest is 81 to 86, my lords. And endorsement is at annexure A15, page 110. There, they say it is 167 and expansion is less than 4 centimeter, which is prescribed. That is the reason I saw.
I think my learned friend has not seen page number 150 and 151, wherein the certificate was given by the board. Here, with an individual doctor he has taken. We can't consider this. This has taken
hospital.
by the petitioner. And 150 and 151, my lord, I will take my lordships to page number 150. The medical test was conducted by the board and all the board members have signed. And there, my lord, they are given chest expansion in typed copy, my lord, at page number 151.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಡ್ತಾರೆ. We are in the
ಆಯ್ತು ಸ್ವಾಮಿ.
second week of December. ಧಾರವಾಡ ಬೆಂಚ್ ಡಿಸಿಷನ್ ತಗೊಂಡ್ರೆ ನಾವು ಮೆನಿ ಮಲ್ಟಿಪಲ್ ಮೆಡಿಕಲ್ ಟೆಸ್ಟ್ ಶುಡ್ ನಾಟ್ ಬಿ ರಿಸಾರ್ಟೆಡ್ ಟು ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದೇವಲ್ಲ. ಇದು ಯಾಕೆ
ಇವತ್ತು ತಗೊಂಡು
ಬರ್ಬೇಕು?
Coordinate judgment has been confirmed by Supreme Court wherein it's with respect to height that it was given, my lord.
Not. Yes, 38.
Bring for the petitioner. This point, lordship has directed them to supply copy also. Sealed cover ಯಾವಾಗ initiate ಮಾಡ್ತಾರೆ ಅಷ್ಟೇ point. Sealed cover initiated after only after the charge sheet is issued. But here, K.V. Janakiraman case completed. Promotion is DPC is held on 31/5/2022.
We'll do it next week.
ಅವ್ರು ಕಾಪಿ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರು, ನಾನು ಕವರ್ ಕಾಪಿನೂ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೇನೆ.
ಕಾಪಿ ಕೊಡಿ.
ಕೊಟ್ಟಿದ್ದೀನಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟು ಇವತ್ತು post
This
ಮಾಡಿದ್ದೀನಿ.
is connected with the other case, your lordship. On the other day, your lordship has disposed of this matter. That is 4.5 crores reported in paper. Bribe, wherein your lordship has directed
What we said in that?
that to complete the process within 1 month. If that inquiry is not completed within month, DPC can.
Satish Bhatt's matter.
Please, lords.
Satish Bhatt's matter.
Same, Alicia and.
WP number copy.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಂದ್ರೆ ಚಾರ್ಜ್ ಶೀಟ್ ಇಶ್ಯೂ ಮಾಡಿರೋದೇನೆ
ಅಲ್ಲ, ಅದು
after
promotion ನ
promotion.
consider ಮಾಡಬಹುದು ಅಂತಾನೆ ಹೇಳಿ.
That your lordship has held.
It has a
is o-
bearing on this.
Even Supreme Court held that.
ಇದೇನದು?
Please, lordship, copy.
ಜಾನಕಿರಾಮನ್ ನೋಡ್ಕೊಂಡೆ ಬರ್ತೀವಿ.
ಜಾನಕಿರಾಮನ್ ಕವರ್ಡ್ ಆಗೋಗುತ್ತೆ ನಂದು.
ಅದ್ ನೋಡ್ಕೊಂಡೆ ಜಜ್ಮೆಂಟ್ ಬರ್ದಿತ್ತು ನಾವು.
Because this is
30869 of 24, your lords.
judgment.
ಅದ್ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Next week.
ನೆಕ್ಸ್ಟ್ ಆಗಲ್ಲ, ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್.
So,
We'll have it day after tomorrow.
No, sir. Day after there's some difficulty.
Your difficulty.
Please, next week any day.
my lord.
I'm sorry, but apologies, I was held up in the other court.
No, we are saying apology now.
Tomorrow my lords have 371J. Tomorrow there is 371J is there. Day after tomorrow, the sub-registrar's direction matter where my lords had issued, that's full day hearing is there in KIT.
Thursday.
That is on Thursday, my lords. So therefore, next week any day, my lords.
That's 5th of December. You just begin. Let us see. If we need, but we will not be able to.
Lord, may I
Today-
just point, may I take my lord, my lords through a particular part?
No, I have to come.
Just-
ಅವ್ರು ಹೇಳಿ.
No. He has to do that, no doubt about that, but we are not hearing him. My lord had directed production of the original document. I would just like to make a few submissions on that so that my lord may be able to.
ಆಮೇಲೆ ಮಾಡತ್ತೆ ಅದೆಲ್ಲ ಇಟ್ಕೊಂಡು ಮಾಡತ್ತೆ.
I'll leave it. I'll leave it.
We'll hear you also.
I have no problem.
In this case, my lord, your lordship had directed me to produce the certain documents of the other matter, Surya Madhava case.
Because KP said, if all this is disclosed, everything will be in black and white anta.
Please, it's ready, my lord. I'll place it.
Okay.
What of-
At the risk of again repeating it with apologies in advance. But the purpose behind my making a few submissions for 5 minutes would be this, that my lords would be able to, we are all seeing every day, my lord's time is a constraint. Therefore, it is my duty to point out
Right.
that a few minutes of pointing this out
All right.
would help.
Please.
He has full floor after me.
Hurry.
What of-
Lord, I'll just take my lords to 6-7 pages out of this whole booklet. The first of which, my lord, would be at page. These are the. Signed one.
Yes.
No, these are. Yeah. This. My lord, may kindly take in the first instance. Page 160, my lord.
Sorry.
These are the pages to be referred to.
ಏನಿದು? What
That
is
is for
this
the-
case about?
My lord, this case,
He seems to have, all he wants is maybe some information from the central government further, alva?
Correct.
That is what he wants to make.
my learned friend is very prophetic. I understand.
He had indicated that. It's not prophetic.
Last time you only said.
You only said.
No.
Ah.
Then his memory is is improving by being in this court, my lord. It is rubbing on to others also, my lord.
We also improve. from
No,
this
no,
side.
I'm saying memory in this court is very good, so it's also improving on my learned friend.
That Panigrahi.
Panigrahi, my lord. Page 168 is Panigrahi. This is the judgment which we are, based on which a decision was taken by the DOPT as well as the UPSC and the review committee, my lord.
What Panigrahi said?
My lord, Panigrahi, I'll take my lords to
We only know Panigrahana.
page 168, my lord.
Yes.
Page 168.
168.
Para 8
168.
at the bottom. The page numbering is at the bottom.
ಮೂರು ಪೇಜ್ ಇದಾವು KT. There are 170.
Pardon?
There are 3 page numbers on each page.
So the printed number 168. Printed number at the center,
In the bottom, my lord, bottom. My lord.
at the bottom.
No, there was-
There's only one.
He's referring to. my
I'm
lord's,
referring to the records
serial
produced.
bind that-
Oh, that file.
The records produced.
Padi.
This,
Ah.
Lord, my exercise would span not more than 10 minutes, then I'll leave the floor to him.
We'll also leave the court. We have one function today.
Please.
Constitution Day, na, today. Mr. Harnally is waiting for which case? Not very sure that we will get a chance to hear you today. And the other one,
ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅವ್ರಿಗೆ doesn't have qualification, he has to complete certificate course. ಅವ್ರಿಗೆ ಇಲ್ಲಿ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡ್ ಮಾಡಕ್ ಹೋಗಿದ್ದಾರೆ ಅದಕ್ಕೆ ಅವ್ರಿಗೆ
and the other short date.
ಮಂಡೆ ಏನಾದ್ರು ತಗೊಂಡ್ರೆ
Monday ಎಷ್ಟಿದೆ matters? Tuesday we'll have that. Okay.
My lord, I'll leave,
Or inform the
leave it
other
to-
side also.
my lord, my instructions are to leave it to my learned friend to start. I will, because we have hardly 5 minutes, let him make his case out.
Hello,
Yeah.
you wanted to say something, na?
No, I wanted to say this, my lord.
Ah.
I will just point out, if my lord see, because since there's no time, I was feeling embarrassed at again.
ಯಾಕೆ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ ಅಲ್ಲ ಏನು ಅಂತ ಗೊತ್ತಾಗ್ಲಿ ಅಂತ
No, it's-
another 10-12 minutes we have. We want to know
My lord, at page,
actually what is the Mr. Kheti?
my lord, this
Just
issue
make
is,
a statement, what is the dispute about?
my lord,
Try to say that.
regulation
Yes,
5,
yes.
regulation 5(2) stipulates.
Lords, under regulation 5(2), my lords, of the highest proportion rules,
Ah.
it stipulates, my lords, the persons who are eligible, my lords,
This is from
SCS.
non-SCS
Non-SCS,
to
SCS, state civil services.
state civil service,
This is
KS
point-
to IAS,
KS to IAS, appointment by promotion. Lords, there is a
appointment by promotion.
promotion.
Correct.
There is a proviso which says that 8 years of continuous service, my lords, has to be rendered
One second, 8 years of service in a feeder cadre, that in KS.
in KS, my lords.
Which grade?
It uses the word deputy commissioner,
Ah.
but also the definition clause says what is state civil services. So now it uses the word continuous service. The only question in my lords is with regard to whether that continuous service is actual service or whether notional service also can be counted. In
How
his case,
section is worded?
section is worded.
Why that question arises? Is he given notional service?
He is
by
given
any
notional
court
service.
case?
He is given, my lords.
He is given notional service.
notional service. Lords, what happened in 1998, 99 and 2000, 98, 99 and 2000, my lords, we had a recruitment of gazetted probationers.
No, we have understood now.
Please.
Because of notional service, this question arises.
Service question.
Yeah, which is the rule which reads that way?
Please, my lords.
Show that.
Lords, page 308,
308
please, my lords,
of
of the paper book, main paper book, writ petition.
volume 2. ಕೊಡಿ. How various high courts in the country have construed that rule?
Notes, in fact, Chandra. Notes, in fact, there is a direct judgment on the point by the Supreme Court and the Madhya Pradesh High Court, which was cited before the tribunal. The tribunal follows, my lords, a coordinate bench edition, my lords, of the tribunal itself, instead of following the Supreme Court judgment, my lords, and the Madhya Pradesh High Court judgment.
Which is
Lords,
page number? You said a particular page number.
My lords,
read that.
it starts at 308, at
08
310 I'll notice on 52.
310. Yes. 52.
Please, my lords.
The committee shall consider the inclusion to the said list the cases of members of the state civil services in the order of seniority in that service of a number which is equal to 3 times the number referred in sub-regulation 1. Provided that, ಯಾವ್ದದು ನೀವು ಯಾವ್ದು
Lords,
ಹಾಕ್ಬೇಕು ಅಂತ ಹೇಳಿ?
third proviso, provided also.
Provided that the committee shall not consider the case of a member of the state civil service unless on the first day of January of the year for which the select list is prepared, he is substantive in the state civil service and has completed not less than 8 years of continuous service, whether officiating or substantive, in the post of deputy collector or in any other post or post declared equivalent thereto by the state government.
Please.
Your version is,
Our
he
version-
should be in the post,
He should be in the post.
whether on officiating basis or substantive basis.
Actual
We
service.
should have actually he has put in service is your version.
That is our version, and that
One
is,
second.
please.
How the judgment which you are referring to, how it reads? Tell us.
Notes,
Which judgment interpreted the actual service? Because in one Rajasthan forest service matter,
Girish-
Supreme Court said it need not be actual service.
please. Lords, in Girish Kumar versus State of Maharashtra, notes,
Same
pass
rule
on.
was interpreted?
Lords, it was similar parameter with regard to IFS.
Baralu.
No, my lords, same, the proviso is the same.
Text will be like that only, but
No, no.
this is not the rule.
No, my lords, it is, we have 3 rules, IFS, IAS and IPS.
Same type of.
Same verbatim.
All India service.
All
rules.
India services. Lords, the court memo is misplaced by my learned friend.
Ah,
Just pass on
right.
my copy.
Read.
Please,
Read. Let's see, we understood the point. What is the version of the central government on this?
Central government
How
says
you operated this particular?
actual service. They have filed an affidavit in this.
Actual
court.
service.
Actual
In
service. And they say-
Panigrahi, what you did?
Lords, Panigrahi, my lords, gave a direction based on notional service. That was following, my lords, a Hyderabad bench decision, my lords, of the Central Administrative Tribunal, has been followed, my lords, by the Bangalore bench here. But before the Bangalore bench, when Panigrahi was sought to be relied upon by the applicant herein, the state had placed on record, my lords, the Supreme Court judgment as well as the Madhya Pradesh High Court judgment in respect of the IFS rules, where the same,
How you did all these years?
my lords, on the basis of actual service.
No, in no case you have considered notional service.
Notional is not considered, and central government also gives the basis for that reason, because it is appointment by selection. When it is a matter of selection, I need their performance in the feeder cadre, in the ACRs, to assess their performance. So there is a basis for the rule. That is what their affidavit also says before this honorable court.
In no other case you have considered candidates of notional service.
No, notional service does not arise at all. We have not considered. Now his case is,
You file affidavit.
shall I file, please?
That if there are at least two cases.
Milords,
of
now what their
notional
Milords,
service.
I'll just put it out, Milords. Central government has implemented Panigrai's case where it was notional. Now, therefore, Milords, their entire endeavor was to try to get the records in respect of Panigrai's case, and so that to show that central government in one other officer's case, notional service was considered based on a court order. So that was their entire endeavor.
Anyway, it is central government who is the author of the rules.
It is the central government, please.
Yes.
Please, Milords.
Who are
If
they?
his understanding of the rule
Please, Milords.
will be very reasonable because he is the author of the
He's
rule.
the author, but he has stated his stand before this honorable court.
No, not stated.
Please, Milords.
How he conducted himself.
In the earlier round of proceedings.
You may state, you may go on changing your color depending upon the requirement.
Please.
Question is not that.
Please.
When you do certain things,
Please.
you publish to the world at large that these are the norms we follow. Justice Felix Frankfurter of US Supreme Court referred to in R.D. Shetty versus International Airport Authority case. And in Maneka Gandhi. If you hold out to the world at large, that this is how we will conduct certain things. You cannot file affidavit and say, no, we will not do that in this case. Read that. What is R.D. Shetty judgment again? R.D. Shetty, B.S. Minas, R.D. Shetty, B.S. Minas, Maneka Gandhi,
Insofar as
Felix Frankfurter of
please.
American Supreme Court. We followed that law.
Please. No, my lords, while we are on the same thing, in respect of this very same rule, my lords, Hyderabad bench of the tribunal and my lords, the Cuttack bench.
How our bench considered, our CAT bench
Have
considered.
just followed Panigree, my lords. They say that we are bound by the coordinate bench decision when I have cited a Supreme Court and a Madhya Pradesh High Court judgment which has not even been considered. There is no
Coordinate bench.
coordinate
not
bench of a
considered.
tribunal.
Huh?
Coordinate bench of
Of
the
that.
Central Administrative Tribunal.
Tribunal.
Ah,
That did not refer to Panigrahi.
lords, Panigrahi is followed by them.
Panigrahi is followed.
Followed.
Yes.
Panigrahi is followed by the tribunal, whereas the state government had specifically my lords, placed on record the stand of the state on the basis of Girish Kumar, that is a Supreme Court judgment on continuous service, and in respect of a similar rule under the IFS regulation, same proviso, which is in pari materia in respect of the Madhya Pradesh High Court judgment. So they say that we are supposed to follow the rule of precedence, and it is by ignoring a Supreme Court judgment and a Madhya Pradesh High Court judgment by following my lords, Cuttack bench judgment. So they have not even referred to our argument at all. They have just allowed it.
But they followed Panigrahi.
Panigrahi has been followed.
Panigrahi is it reflects the conduct of the central government
Please,
with regard
Milord.
to how these rules should be understood.
Milords, it is, I would say, if it is the only case, Milords, where the conduct is evident, then that is one thing. It is not that in other cases on all, it's a different stand. They have defended, Milords, with regard to continuous service. And they have succeeded in those cases before the Supreme Court and before the High Courts in the Madhya Pradesh.
Correct.
They may succeed in this matter.
Please, Milords. Therefore, Milords, what I would put in case
But
I have to, Milords, the state has to make a stand clear.
This is the only issue in this matter.
That is the only issue.
That's all.
Lord, he has no locus before this court is
No, then
is the
delete-
basic stand. But for the purpose of finding out whether others have been given or not, kindly take my volume 3 where my rejoinder is, where I've
To
collected
others
everything.
also. To others also.
To others also, let them both come and say, then once again, whether they have given to these people or not. It is not the only case as far as the DOPT is concerned. No.
He has to point about, insofar as the state, I will file an affidavit.
Yeah,
Milords, Milords,
but in
let
the
him-
context, we will give them the context for the
Milords,
state
I'll
also.
Context.
Please,
Kindly see page 400
That's the only point.
that's the only point.
That's the case, sir. Whether it's should it be officiating or substantive service
Yes.
or notional service can be taken note
Taken
of.
into note.
is the
That-
issue.
that is all
Kindly-
point.
That notional service arose because of CAT judgment or KAT judgment.
CAT judgment.
KAT judgment. Okay, got the point.
which in turn is following Supreme Court judgments also. The Panigrahi
clear.
judgment also has reference to other judgments.
Which page you want us to see
My lord,
that?
here, for this purpose, for the limited purpose of today,
Hey,
page,
today, over, only that much is the case. Where is the other point? What meaning should be assigned?
then I'll just read
The
Panigrahi.
expression
Then I'll
in
take,
that sub rule 3, regulation, sub-regulation 3 or 4?
5-2.
5-2, no, 5-4.
5-2.
5-2,
Third
no,
provi-
proviso,
Third proviso to 5-2.
5 proviso to 5-2.
5-2.
This is the only, yes, what is?
my lord, at page 467 of my third volume, these are the people who have been given, these are the officers who have been notionally promoted by the DOPT. Therefore, notional promotion is not something new with Panigrahi. It didn't start with Panigrahi. Please see 467.
467.
Yes, I put a table there.
Chudamani said, he has been notionally promoted to
are
IAS
16
cadre
there are
from
six-
1/6/2012 with consequential benefits by the DOPT, consequential benefits also given.
Yes, 16 names are there. and
Ashwini Kumar Gupta. All these are notional.
all these are notional. And also
But
the,
No, no, Lords, there
What
could be
is-
one confusing, notional means, suppose select year is a 2019. Suppose he gets selected, my lords, after 5 years, because of some court order, there is an intervening litigation. Suppose he's
Previous
promoted
service also.
as against 2019, if he gets selected, giving a notional date of promotion is one thing. My learned friend has to answer whether the service rendered in the feeder cadre notional has been taken into consideration. This refer to notional promotions. For example, my lords, promotion ought to have been given in the
Particular
selected
date.
particular date. IAS promotion itself is deferred for some reason
But
Then-
service as such is done by that candidate in that feeder cadre.
in the feeder cadre. So maybe the central government can state with regard to these things also, my lords, because
Please, you clarify.
Please, if your lordship may
ಅಷ್ಟೇ
ki-
ಕೇಸ್ ಇದು. ನಾ ಇಷ್ಟೆಲ್ಲ ದಪ್ಪಿರೋದು ನೋಡಿ ಹಂಗಾರೆ ಏನ್ ಭಾಳ ಎಂತದ
ಇಲ್ಲ, if your lordship may kindly come to page 200.
and
Lord,
there is
before that, my lord, before that, with the caveat, my lord, that learned ASG is leading us in this matter. The first point, my lord. But my lord, since your lordship pointed out, with regard to the Surya Madhava case, my lord, if your lordship may turn to page 200 of the compilation I have given, it's a notional promotion, I think 8 years. If your lordship may, I'll just point out the judgment when my learned friend referred to the Andhra.
ಅಲ್ಲ you suppose you are standing beside Kheti or you are standing beside our learned age.
My lord, to
Beside
be,
whom?
to be
Or
honest,
maintaining distance, equal distance.
my lord, to be honest to the court, and an officer of the court, initially, before the CAT, we filed an application, we filed objections, we were with the state. We changed our version
After seeing
after seeing
the color of the state government.
Then, my lord, now also
No,
we
no,
have filed,
State government.
ಅದೇ ಗೊತ್ತಾಯ್ತು. ಅದೇ
now also,
State
my lord, we have filed an application. Therefore, my lord, it is better, my lord, for the ASG to argue the matter. My lord, to be honest to the court, I have made my submissions, my lord.
ಅಷ್ಟೇ ಕೇಸ್.
ಇಲ್ಲ, ಅಲ್ಲಿ ASG
ಇದರಲ್ಲಿ ನೋಷನಲ್ ಪ್ರಮೋಷನ್ ಕೇಸ್ ಇದೆಲ್ಲ ಆಕ್ಚುಯಲ್ ಸರ್ವಿಸ್ ಇಸ್ ನಾಟ್ ಡನ್.
ಇಲ್ಲ, that is not there.
No, no, my lords.
no, no,
Yes,
that is,
no.
Your lordship may.
that is why we will have
Please,
to
sir,
make
let-
some submissions, my lord.
He
It
has to-
cannot be
we have
just
to
ad
make-
hoc. But the point is, why I wanted to point out that from their file, as my lord rightly said, that if they have agreed to it, they have said, yes, they have modified their written statement before the KAT and then said, yes, he is entitled to. After that, what happens?
Lord, that is the
Who
reason
is
I
the
couldn't-
author of this?
But-
Who are they? What is their locus?
Lords, if for just
And the
to-
rest of it,
just to rebut him straight away, if according to him we have no locus, he should not have made us a respondent, he should not have sought any direction against us. Let him delete us from
There
the
is
other
a-
parties,
there is-
we can go out.
there is
straight
a, yes, there is a thing called,
We are also aware
away. Please, my lord.
that sometimes clients will be behind you and they will ask you what argument you
my lord, but I would say this, my lord, with a little risk of displeasure, That who is behind him is also a question to be asked, my lord.
We can find.
Who is truly behind him?
That Mr. Keti coming to the court that because I am deprived of IAS, etc., etc. But we are. It is a little
But if they
difficult
say,
for you
please, my
and
lords.
for you.
Mr. AG,
Please, my lords,
if they say
please.
all these are notional service candidates,
No, my lords, if they say all these are actual notional, my lords, that's what I said. Let them say
Our
that
contention
they have
before the
taken.
cat was that only, my lord.
My lords,
We've changed it. My lord, it's true that we have done it. We have changed it.
my lords,
Initially, we were there, we have filed objections. Thereafter, we changed our version. Therefore, my lord, my humble submission is this, my lord, for the time being, my lord, what I could make my submission is only based on the judgment of Surya Madhava case, my lord, which is not in, with regard to the actual promotions, it's with the
No,
notion.
that is why, even though why I was pointing out the records is,
no,
not,
ASG also.
notwithstanding the categorical,
He's on his legs in the first court, my lord.
The first court.
First court.
We'll
So
have it
perhaps-
only that much.
only that.
Have it tomorrow, you come and.
Please,
argue
my lord,
this
may I
and
just
find-
point this out, my lord?
Yes.
Page 467 is that list they need
Yes, I
to,
have seen that.
they will have to answer. And my learned friend will have to answer from page 470. They have also given notional promotion. Let them come and explain this first,
We'll
then
answer.
start their arguments.
We'll answer.
70,
We'll answer.
170.
I'll answer.
How they have given
learned
for KS.
ASG.
Within KS, how they have given this notional promotion.
Learned ASG to answer as to.
Para 19.
Hmm?
Para 19 onwards, the names which are given there.
No, no, 467.
470.
467.
467 is for ASG, my lord.
Central government.
No, they are for central government, nah?
Yes, yes.
But for state.
For state is at para 19, 470 onwards.
470.
Yes.
Lords, we will answer 470.
Para 19,
Central has to
470.
answer 467 and 468.
For,
460.
learned ASG, the learned additional advocate general to state
Please.
as to whether, how many they are? 10%.
10%, my lords.
10 employees enlisted in para 470, page 470 of volume 3 were considered for promotion to IAS, KS,
KS on notional promotion.
on the basis of
Notional, concept of
notional
is-
service,
Yes.
though
That's the
they had
principle.
not put in actual service in the feeder
Feeder.
cadre. First. Similarly, the DSG has to state as to whether the 16 candidates enlisted at page 467,
And also one more at page 14.
that is Yashwant,
Yashwant Gurukar, yes.
and another by name Yashwant Gurukar appearing in page 469
470.
were considered for promotion to IAS on the basis of notional service, though they had not put in actual service, officiating or substantive in the feeder posts or cadres.
Lords, for the state, my lord said 2 KS, it has to be twice.
State of the mail market.
State the IS Act.
No, no, it is not 2IS, KS only.
KS notional.
It's notional. Notional in KS. How could you give notional? The
But he has
principle is,
also got notional in case. No notional in
No,
case
no,
is
no.
not even a problem.
how?
I can straight away make a submission.
His
We'll
submission is
answer
not the
this.
point. How he has given that. If notional is
Day
not
after tomorrow.
permissible, how it is
Lords,
given?
Day after next week, my lords.
Next week.
Next week.
Monday. Only this much.
Only this much.
Over.
My lord,
Ah.
may I request your lordship, my direct.
Registry to share a copy of this order,
Lord, may
carbon
take it,
copy of this order with the learned AAG and learned DSG.
Great.
for
Lord, may take
compliance.
it at 2:30 or how does my lord wish to take it?
Monday. 231. Well, let it be in list. If it reaches, we'll pass over.
Please, please.
You just keep some
Please.
colleague of yours here.
Grateful.
No, no, not for that.
Ah.
It's not for me, for my purpose. It's for us to detain my lords, my lord.
No, it all depends upon.
Please.
One, na? Na? Okay,
Obliged.
only that much.
Only
That's the
that.
case.
That's
Okay. No, great.
Then the last page is the set of parties. Monday post. The repetition number is the last 30. Date of Karnataka. Vishwanath Hiran. ಈಗ ಐತಲ್ಲ last. ವಿಶ್ವನಾಥ್ ಶೆಟ್ಟಿ. Date of last ನಡೀತಾ ಇತ್ತಲ್ಲ 39th matter. Number repetition number. Thank you.
8/1/19. ಸುಮ್ಮನೆ ಬಂದೆ. ಬೋರ್ಡ್ ಲಿಸ್ಟಿಂಗ್ ಏನ್ ಮಾಡೋದು, ಕಷ್ಟ ಪಡುವೆ ಲಿಸ್ಟ್ ಮಾಡ್ಸಕ್ಕೆ. ಬರ್ತೀನಿ. ನೋ ಪ್ರಾಬ್ಲಮ್. ಬಿಸಿ ಇದ್ದೀರಾ, ನಾನು ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತೀನಿ. ಹಾ ಸರ್, ನೋ ಪ್ರಾಬ್ಲಮ್, ಮುಗಿಸ್ಕೊಳ್ಳಿ. ಎಲ್ಲ ಕಾಪಿ ಇದೆ. ಎಷ್ಟು ಕಾಪಿ ಇದೆ ಅಂತ.
Waiting, waiting.